is there any motions on behalf of the defense?
Yes, Your Honor. After, as required, after the state's rebuttal, we would renew our Rule 29 motion, Your Honor, incorporating the same arguments Ms. Stevens made at the end of their case, the same arguments that I made at the end of our case, Your Honor, and indicating that reasonable lines cannot differ at this degree, Your Honor.
Any response?
I think that we've met our burden and ask the court to deny the motion.
At this time, I will deny the motion. Is there anything else we need to discuss prior to bringing in the jury?
Make sure the record's clear. We're satisfied with the change to the jury instructions, but previously we've had discussions and we hold on to those objections.
So noted. Anything on behalf of the defense?
Not on behalf of Mr. Meade, Your Honor.
All right, let's go get the jury.
Thank you, Josh.
Jill, you'll probably be happy to be back in front of Judge Sarah.
That's what people do. It's been quick.
What's that?
All rise.
Everyone can have a seat. Ladies and gentlemen, I have made a revision to the jury instructions. If you can turn to page 7, and I'll direct you to the third complete paragraph where the defendant maintains after Casey Goodson posed an immediate threat of serious physical harm was included. I failed to have that in the prior jury instructions. What we're going to do today, we're going to have closing arguments this morning, and then you'll retire to deliberate. Are there any closing arguments on behalf of the state of Ohio?
Yes, sure.
I'm going to get this live stream off of my...
May it please the court, counsel. ladies and gentlemen of the jury. 6 shots in the back. No matter how Mr. Collins and Mr. Nolder twist and turn, it is still 6 shots in the back. Now, we talked in voir dire about burden and standard of proof, and the state had the burden to go forward with evidence to prove by a standard of proof beyond a reasonable doubt, the charges of murder in count 1, murder in count 2, and reckless homicide. I submit to you, ladies and gentlemen, that we have done that. We have shown that on December 4th, 2020, in Franklin County, Ohio, the defendant purposely caused the death of Casey Goodson Jr. We've also shown that on or about December 4th, 2020, in Franklin County, Ohio, the defendant caused the death of Casey Goodson as a proximate result of knowingly causing serious physical harm. You've heard the instructions of the judge. Knowingly causing serious physical harm is the offense of felonious assault, which is a felony of the 2nd degree. And when that is the proximate cause of death, in Ohio, the crime is murder. We have also shown that the defendant recklessly caused the death of Casey Goodson Jr. There is no real argument that exists that the state did not meet its burden and did not reach its standard. Now, we heard time and time again, well, you know, when a police officer shoots at someone, he wants to stop the threat. Stop the threat. That, we heard it, you know, Mr. Collins elicited it from pretty near every police officer that testified. You heard Mr. Davis say, yes, it's to stop the threat, stop the threat. And somehow the implication is that when you point an assault weapon at an individual and you fire it 6 times, either on automatic or semi-automatic, at center mass, the vital organs, that there's no purpose to kill. But you've heard the judge's instructions. Purpose means it's not accidental, it's intentional. You did it on purpose. The instruction tells you that when you use a deadly weapon, and that, ladies and gentlemen, is a deadly weapon, on someone, you may infer purpose. You don't have to, but you may. And I submit when you're 10, 12 feet away from your target, when you've got a sighted in on the vital organs of the center mass, and you discharge that weapon 6 times, 6 bullets, purpose to kill is there. Certainly knowingly causing serious physical harm is there. Knowingly is a slightly lesser standard than purposely. But when you point a gun at somebody and pull the trigger, you are out to cause harm. So if somebody gets up here and tells you, oh no, just wanted to stop the threat, wanted to stop the threat by purposely causing death, by knowingly causing serious physical harm, or the last mental standard, reckless, which is the lowest of the three mental standards, talks about heedless indifference. Point a gun at somebody, heedless indifference, pull the trigger, that's reckless. That's knowingly, and that's purposely. So I submit to you that there is no valid argument on any of the elements that the state has to show to prove the charges that have been lodged against the defendant. I hesitate to say this, but it's almost like it's beyond all doubt. Does anybody have any doubt as to how Casey Goodson died? He died from 6 shots from the defendant that the defendant acknowledges he fired, that even without the defendant's acknowledgement, you had Caleb Worley come in. He looked at the 6 shell casings that were collected. He looked at the 5 bullets, spent bullets, that were collected either from Casey's body, or that were collected at the site of this, out of the wall of the kitchen, out of the microwave in the kitchen, off the floor of the kitchen. And he compared them, and he told you they were fired from the defendant's weapon. So let's get to what this case is really about. Remember back in voir dire, I talked about the different ways that you defend a criminal case. The Sodai defense, some other dude did it. Doesn't come into play here. There is no question who the participant in this case are. And then the defense of, what is it? Is it a crime? Is it not? Again, the elements are all established, but we have a variation on a what is it, the yes but, the affirmative defense of justification. That's what the defense has raised. And let me remind you, it's their burden to prove that. It's not our burden. It's their burden to prove it. And they've got to prove it to you by what we call a preponderance of the evidence, the greater weight. Put very simply, if you balance all the evidence and it's a tie, they lose. They didn't sustain their burden. They didn't reach the standard that their burden requires. And you have the definition for the justification defense. It's a complex one, and not easily understood, and you know, gives latitude to police officers, which they should have. They're doing a dangerous job. They're in dangerous situations. They should have some latitude. They can be mistaken, and a honest mistake, you know, shouldn't be held against them. But remember, this is not what the defendant thought to establish the justification defense. It is what an objectively reasonable officer standing in the shoes of the defendant would have concluded and what action he would have taken. So just because Mr. Meade says, I had to do this, you don't have to accept that. Not if, looking at all the evidence, it doesn't make sense. Because if you look at all the evidence and it doesn't make sense, then an objectively reasonable officer with proper training would not have fired shots, would not have killed Casey Goodson. Now, the defense brought in an expert to help you. We brought in an expert to help you. You'll have to decide who to believe, because I think you saw very contrasting presentations from the experts. You saw a retired officer, spent 30 years, about half of it training other officers on various things, not just use of force, who said, you know, if you got a hunch, you know, if he could have caused harm, you know, there's the risk. He had to stop the threat. What threat? There was no threat. And then you had Professor Stoughton, who granted what hasn't been a police officer, or I mean, he has been a police officer, but he hasn't been one for 30 or so years, who talked to you about the practices and principles and how they've developed and how they try to train and teach officers and so forth. And freely acknowledged that, yeah, you know, somebody with a gun is a threat. But is he an imminent threat? Is he an immediate threat? Do you take the kind of action that the defendant took? And he walked you through the actions of the defendant that day. You know, he told you about, you know, we train police officers to create time, not to minimize the time. You know, distance is your friend. He's got a long gun. He's got a long gun that he's taking on a handgun. Who's got the advantage? He doesn't have to be 12 feet away from it. He could have been 20 feet away. He could have been 100 feet away. You've been out to the site. You know the distances involved. Elmo, please. Right there. Doesn't need to close the distance any closer than that. He could have been standing behind the tree, position of protection, cover. Doesn't need to be up there at the gate. He could have effectuated everything right from there. But instead he closes the gap. And, you know, we all chuckled yesterday when Professor Stoughton was questioned about the pants on fire fella. You know, yeah, he closed the gap there. Why? Because the man's pants were on fire. Casey's pants weren't on fire. No reason to go any closer than that. So, as you look at the evidence, and as you consider the viewpoints of the experts, who are you going to listen to? Who seemed to be an expert to you? Who educated you about police practices, about how police analyze situations? It was very analytical, very logical, and one that showed you how a well-trained police officer, an objectively reasonable police officer, can do things to protect his safety and minimize the risk to others. We heard the defendant's philosophy. I hunt people. I throw the first punch. Here he fired the first shot. Not only the first, but the second, the third, the fourth, the fifth, and the sixth. 6 shots in the back. I throw the first punch. That's not what they're trained to do. That's not keeping himself safe. That's not keeping others safe. That's murder. You heard Professor Stoughton, and he told you over and over again, despite being asked to resolve factual conflicts, that's not my job here. My job is to come in here and tell you about police practices and how a well-trained, reasonable, objectively reasonable police officer should act. When there are factual conflicts, that's your job. Did you hear that from Kevin Davis? Did you hear him say, oh yeah, you know, there are discrepancies here. I mean, my goodness, you know, the defendant says that he turned and shot him, but all the shots were in the back. Meaning Casey's back is to the weapon when it's fired. Did you hear him say, you know, that's a dilemma here that you, ladies and gentlemen of the jury, will have to resolve? No, he didn't. He said the defendant acted appropriate all the way through. He accepted carte blanches the defendant's explanation. He didn't give you what a objectively reasonable officer would do. He gave you what the defendant did and said, hey, it's all right. He was an advocate. He wasn't an expert. He was in here telling you why you know, the defendant acted properly. He was advocating. That's not the role of the witness. The role of the witness is to give you information. The advocates are all sitting at the tables here. Take that into account when you evaluate his testimony and you evaluate his conclusions. And you make a determination as to whether he supports, that his testimony supports what they are required to prove. Now let's talk about the evidence. There's a hard and true fact in nearly every criminal case. You have to determine the credibility of the witnesses. Just because somebody got up there, raised their right hand and promised to tell the truth, doesn't mean they did. But let me tell you something. Physical evidence doesn't lie. It doesn't have a credibility test. It is what it is. Physical evidence doesn't lie. People do. And I submit to you that one of the first things that you want to look at in evaluating the credibility of an individual is how it compares to the physical evidence. Because physical evidence doesn't lie. People do. You want to look at motivation. Who on that witness stand had the motivation to be untruthful? You'll have to decide. Was it Sharon Payne? We need to go to the computer. You heard her testimony. You heard the agony of that day. Did she strike you as being deceptive? Did she sound untruthful? Because the other thing you heard was her calling 911. And I want you to listen to it now.
911, what is the address of your emergency?
3996 Estates Place.
And what's the emergency?
My grandson just got shot in the back when he came in the house, and I don't know if he's okay because it's still out there.
I'm sorry, what just happened?
My grandson just got shot
Okay, where did this happen?
at my house. He lives there
Okay,
with me.
so who shot him?
I don't know. I just
Okay.
heard the gunshots, and I would get up, and he's laying in the door.
Okay. And nobody saw anything prior to this?
No, he went to the dentist or somewhere and came home, and all I know has a bunch of gunfire. He's not a big kid. He doesn't have a police record. He works. I don't know what happened.
Okay, is there anybody in the house that can tell you who shot him?
No, they don't know. They were threatening everybody in the house. I don't know what the fuck's going on.
That's okay, we've got help headed that way. Did they say if anybody was outside arguing with him or anything?
Pardon me?
Is he breathing?
I don't know. They won't let me in the kitchen by him.
Okay. Did he say if he had, like, any disputes with anybody?
No, not that I know of. I'm not aware of anything.
Okay, what's your name and telephone number, ma'am?
Sharon Payne,
Okay.
614-597-5570.
Do you know if he was dropped off by anyone?
No, he went to the dentist or somewhere. He was driving my car. I don't know what happened.
Okay.
I don't know what's going on.
All right. Well, the officers
There's a
will be
black car
that
out
way.
here waiting.
I'm going to go ahead and get the medics started that way, okay?
That's the damn police. Hold on.
There.
Give
Okay.
me that squad.
Ma'am?
That's the police.
Yeah, the police are there, and they've got the medics too, okay?
Why didn't you stop?
Grab a collar for your dog. We need everybody out of the house.
Don't have a collar.
Okay, everyone out of the house. Grab your kids.
Inconsistent with her testimony? I don't think so. That's as it was happening. You got the storm door. What do we know about the storm door? Well, there was glass in here that got knocked out from the defendant's shots. Three bullet holes. And the way the bullet or the screen is bent, Amy Culia was able to tell you the trajectory of these three shots. You'll have her diagram back there. We have a nick up here, another bullet. In order for, we know that Casey was inside the door. Defendant told you that. Makes it kind of difficult to turn and face the defendant with a door between them. We know the inside door is open and undamaged. So none of the shots hit it. It was open when the shooting occurred. And guess what's in the inside door's locking mechanism? Casey's keys. He'd unlocked the door. He'd opened the storm door, unlocked the inside door, and had swung it open enough that it was out of the range of the bullets that struck him and passed through him and passed through this door, because all the bullets passed through this door. It's just happened to have this screen to protect, probably because of the big dog. That's the only reason that we have what we have there, because all the glass was, and you'll see it in the pictures, all the glass is on the ground. It's shattered in small granules. I think they make glass that way so that you don't have the sharp pieces that cut people and stuff. Physical evidence doesn't lie, ladies and gentlemen. People do. What else does the physical evidence tell us? We've got Casey's gun. This is the safety on the gun. Safety is off when it's down so that the slide can move. Safety is on when it's up. crime scene search unit documented the scene, one of the photographs they took, and you'll have it back there, although it's difficult to see on the printed photograph. The gun. Josh, were you there? Where the circle is, that's where the safety is. It's not down, it's up. So what's that tell us? It tells us that Casey had the safety on in his gun. If you're going to shoot someone, you take the safety off. Otherwise, the gun won't shoot. When would you have the safety on? When the gun's in the holster, because you don't want to shoot yourself. And you're not going to shoot it while it's in the holster. And this is the holster. Pretty flimsy. So you decide. Did Casey pull the gun out of his holster and turn and point it at the defendant with the safety on? Or perhaps it never left his holster until after he was shot. Remember, there's an extended clip in here. You can't put it because they've made the gun in such a way, thankfully, that it's very safe, can't be fired, but it had an extended clip, which makes an extended loaded clip, which makes the grip part all that much heavier. And you heard from Detective Hughes, I wouldn't have a holster like that. You know, why not? They'll fall out. There's no restraining strap, nothing to hold the gun into the holster other than your body in the holster. So it's not hard to imagine, as Casey fell, the gun falling. And where would you expect the gun to fall? Right where it was found, under his torso, under the right side of his torso, right where it was found after he was rolled over. Physical evidence doesn't lie. People do. We got AirPods, and you'll have the AirPods back in the jury room. Here's where they were documented laying on the floor after the medics had removed Casey. And after the medics, remember Kyle Lighthizer told you, yeah, they were in his ears. As I was assessing him, I'm doing an assessment, I took them out of his ears. This is his dew cap, like a skull cap. What do we know about the AirPods? Well, we know from Casey's phone and Detective Howe that they were connected to his phone. We know from Google records and YouTube music that during the time this all happened, music was playing. And I know the defense is going to say, well, we don't know how loud. We don't know how loud it was playing. You know, and we don't. But we know it was playing. We know they were in his ears. We know that when AirPods are in somebody's ears, and depending on the volume, and I don't have AirPods, you've seen my technological skills. I don't know how to operate them. I don't know how to use them. After I turn the computer on, everything else I have to call my 7-year-old granddaughter and ask her how to do it. But how many times have you had AirPods and didn't hear somebody talking to you? How many times have you had to shake someone who was listening to AirPods because you wanted to get their attention? Physical evidence doesn't lie. People do. We've got a bag of Subway sandwiches. Sorry, I'm just going to switch back on you here. And here's Casey carrying the bag, heading to his car. Just bought them, 3 subs. You'll have the receipt. Here's where they ended up, on the floor of the kitchen, right between the stove and the refrigerator. Not underneath him, because he was carrying them in his hands. Not underneath him. They're off to the side. Physical evidence doesn't lie. People do. So let's imagine, or let's process all the things that were going on at the threshold of Casey's home when he returned that morning with the sub sandwiches. He's got the subs in one hand. He's got a pretty bulky set of keys, and you'll see that. Didn't pull the picture, but you'll see the keys hanging in the door. We know he's got the Subway sandwiches because we see him there at Subway shop, and we see him on the kitchen floor. The only way they get there is somebody transports them, and Casey's the only one to transport. We know he had the keys because the keys are there to unlock the car, unlock the door. And on that set of keys is the car key. It's right above the little Mickey Mouse statuette. So he had to transport the car keys that have the house key from the car to the back door. So, one hand, Subway sandwiches. Other hand, keys. I submit they're probably in his right hand because he's right hand dominated, but more importantly, the lock and the door, the handle to the door are on his right side. Gun. Well, we know he's got the gun. It's out of hands. Where's the gun? The gun's in the holster, in his waistband. Kyle Lighthizer told you, I saw a holster in his waistband. Officer Rosser told me, I saw a holster in his waistband. Subway sandwiches, keys, gun. What's he turning point with? The Subway sandwiches? 6 shots to the back. Not the front, not the side, but the back. His back is to the shooter. Professor Stoughton told you, yeah, of course somebody with a gun is a potential threat. A potential threat. But we don't have our police officers acting on potential threats. What happens when they act on potential threats? Exactly what happened here. And that's not justification. That is not justification. Now let's talk about the shots themselves. This, I guess we need the bottom here. This is the diagram that Dr. Shepler prepared based on her findings in her autopsy. And it's showing the upward trajectory of each of the bullets, because they all were going upward. None of them were going down. We got the 3 in the upper back. Now, we're gonna hear, well, wait a minute. That's all based upon standing up straight. Well, yeah, they've got to have some metric to measure off of, and to set it forth. And people aren't necessarily standing up straight. They move, they twist, and so forth. But what can we tell from this? I submit to you, ladies and gentlemen, that the first thing that stands out is that the 3 shots in the upper back, the ones that did the most damage, were the first shots. Because though Casey may not have been standing straight upright like this in the diagram, he was more or less in that position. And they all have very similar upward trajectories. But let's look at the lower shots. And what does that tell you? Well, your body has a pivot point right around the waist. And so as you bend, a shot that would normally pass through you at the the upward angle that you see in the upper shots gets a sharper angle because it's coming in as you are bending. If it's below the pivot point, you have a bit less of an angle. But here, we have a sharp angle that's right above the pivot point. We have the shot in the buttocks that it has a lesser angle. And then we have the gash in the side that has a sharp angle. Consistent with falling. Consistent with falling. And if the first 3 shots are the upper back, what are they going to cause? Falling. So I'm sure we're going to get some demonstration again of twisting and turning and getting the ruler out and so forth. But what makes sense here? What makes sense? Now let's talk about the timing. Because if, as the defendant claims, Casey has turned his body to point the gun, he has to have turned it all the way back, pretty much square to the shooter, before any bullet strikes him. Does that strike you as reasonable? Did they establish that to you by a greater weight of the evidence? By a preponderance? I mean, there are quick people out there. There are people that are very fast, but that's like lightning fast. 6 shots to the back. The bottom line, ladies and gentlemen, the physical evidence just doesn't line up for them. It contradicts everything that the defendant claims happened in that doorway. It just doesn't make sense. Play the lights video. Remember what the defendant told you after the shooting, the priorities were? Make the house safe. Make the house safe. And by the way, he supposedly first is inquiring, why is a man coming into your house with a gun? Did you hear that from Ernest Payne? No. Ernest Payne said they pointed a gun at me. I'm holding my 3-year-old daughter, and they said, get on the floor. Did you hear that from Sharon Payne? No. Ernest told you because Sharon was obviously tunnel vision. You know, Ernest said she was right next to the guy, to the marshal with the gun, and he's telling her, "Get back," you know, and she's not paying any attention. But it's not. Why is somebody coming into your house with a gun? You heard at the end of the 911 tape. You hear the marshals. And did they seem concerned about who is this guy that came into your house with a gun? No, they're herding them out. They're pushing them out of their home. Sharon Payne told you she went to or headed to her closet to get a coat. It's December. You know, she's got small children, to get coats for them. They wouldn't even allow that. Get out of the house. Get out of the house. We got to make it clear. And the defense says, yes, that's the priority. We got to make it clear. We got to clear the house. Well, let's see how much of a priority it was for you. We need the computer again, please. Okay, stop.
That's ideal.
This is Officer Sam Rippey's body cam. You'll have the whole body cam back there, but Officer Rippey is one of the first officers to arrive there, and he's moving forward with his gun drawn. He doesn't know what's going on, because guess what? One of the practices and principles of policing, communicate. It wasn't happening. It didn't happen. I guess clearing the front yard was important. I mean, that's the defendant. And they haven't cleared the house yet. Okay, go ahead. Let's see what he does.
Okay. We got a medic on scene, but
Yeah, I know. That's what I said. Don't send him in yet.
okay.
The medics are there. Help is there for Casey. And what does the defendant say? Hold the medics, because the house isn't clear. Okay, go ahead.
Tell them to stay. Tell them to stay. Come out this way, folks. Come on.
He'll keep getting his sleep. But do you notice the change in the taillights? Back it up and play it again. The defendant's getting into his truck.
Come out this way, folks. Come out. Hey, come out this way. We'll send him.
Now that sure was a priority, wasn't it? Better get my lights on. House isn't cleared. I just shot a guy 6 times. He's lying on the floor, dying. And the defendant's out turning on his lights. How's that a priority? Mr. Schroyer asked him about it. Oh, I don't remember doing that. He had 0 explanation for it. Physical evidence doesn't lie. People do. Where else has the defendant lied? I strike that. I'm not going to call him a liar. Where else has the defendant been deceitful? Well, we've seen over and over again the intersection at Ferris and Carl. I think it's important that you remember that the defendant provided a statement to investigators. And in that statement, he said, or wrote, as I was sitting at the light at Ferris and Carl, I see this car approaching southbound. He stops because there's northbound traffic coming through. And as he stopped at the intersection, I see him waving a gun. And as he stopped at the intersection, I see him pointing the gun at the car proceeding through the intersection, the northbound car, tracking the driver. And that alarmed me. And then, once the northbound driver cleared the intersection, he then turned left in front of me. And as he came by me, he pointed the gun at me. Then he drove on. That's what he told investigators through his written statement. You've watched that Ferris and Carl intersection video time and time again throughout this trial. Casey never stopped. It was a continual left turn. What's the defendant's explanation? Oh, well, I was wrong. I guess he didn't stop now that he's confronted with the physical evidence that doesn't lie. He's got to back off. But I still saw everything that I saw. In fact, as he went by me, I ducked and I reached for my gun. Okay, there's the left hand. And I'm narrating on the radio, handheld. There's the right hand. What's he driving with? What's he turn around with? But that's not all that exists in this case to show you the fabrication at that intersection. You heard yesterday from Christopher Corne. And Christopher Corne, as we all now know, by happenstance, was in the van immediately behind the defendant. And what did Christopher Corne tell you he saw? He said, I saw this young man dancing in his car, consistent with what we know, AirPods, playing music. And he said he even looked like he was singing. You wouldn't want to hear me sing. But time and time again, when I'm in the car by myself, I'll sing along with the, don't have AirPods, along with the radio. And I'm good then. What's that consistent with? It's consistent with the YouTube music. It's consistent with the AirPods. Now, they're going to get up here and they're going to tell you all the reason not to believe Christopher Corne. Because, frankly, they know that if you believe Christopher Corne, then the case is over for them. Because he exposes the cover-up. And it began with when he turned his lights on while Casey was dying on the floor, and continued when he submitted his statement with this supposed pointing of the gun. Because if Casey didn't point the gun at him, where is the risk? Where is the need to the urgency to do anything? If he'd been or followed his training or been properly trained, there wasn't a need. He would have wanted to build time, as Professor Stoughton told you. Create time, create distance. But boy, take out pointing the gun at the intersection and everything collapses. So what about Mr. Corne's testimony is unreasonable? Well, I think the fact that it came at the last minute, that he didn't make himself known to law enforcement, that's something you can consider. But you've watched this, or you've been here every minute, and every minute you've been here, that camera's been here. They aren't just taking home movies. They're broadcasting it everywhere. And back when this happened, there was all kinds of coverage in the media. So is it that astonishing that this guy says, no, I really didn't want to get involved. Once he realized that there was something there, that he had seen something of importance, because initially he didn't know. He turned around and followed the defendant and Rosser because he's a little ghoulish, I guess. You think, oh, they must be going to do something. Maybe I can be a little entertained. Maybe I can see somebody's door get kicked in or something like that. You might not choose to do that, but there are people that chase fire engines. There are people that have police scanners, and they're listening all the time to the activity because they find it interesting. But once he figured out that, oh my goodness, I was right in the middle of this. Is it astonishing that he didn't want to be part of it? But yet, he also recognized that he did have an important piece of information. So, when asked, why did you come forward? He said, I just had to do the right thing. I had to do the right thing. And it was the right thing. He wasn't obligated to come forward. He did nothing wrong. You witness a bank robbery and watch the robbers jump in the getaway car and drive away. You're not obligated to follow them. You're not obligated to stand around there and wait until the police came and say, hey, I saw the robbers go that way. You're not obligated. We hope citizens will inform the police of of information. It's helpful, absolutely. But it's not an obligation, despite what Mr. Nolder would make it sound like. Now, Mr. Nolder's a very skilled lawyer, and I think if you watched the cross-examination, you saw a skilled lawyer at work. Because Mr. Nolder said, well, you wanted to do the right thing. Was it the right thing to take down your Facebook? And Mr. Corne said, well, I suppose not. Nothing wrong with him taking down his Facebook. I'm a technological caveman. I'm not on social media. I don't know any of that stuff. Got to call my 7-year-old granddaughter to find out. But it makes perfect sense to me that once media got a hold of his name and broadcasted it throughout the whole area and so forth, and he opens up his Facebook, and here are 100 or more friend requests from people he has no idea who they are, that he's think, man, you know, the easiest way to stop this is to take down my Facebook. So was it the right thing to do? Depends on your perspective. Was it the wrong thing to do? No. There's no obligation. Mr. Nolder made it sound like it was an obligation. Mr. Nolder made it sound like he was doing something wrong. He did nothing wrong. He took his Facebook down. He had made a number of posts, apparently, and I had to call my 7-year-old granddaughter to find out what all that meant. But I guess on the news or on the internet, you have the ability to post, write a comment or put a thumbs up or, something like that. And he did that. And then he took them down. Because shockingly, as he was progressing through this as to whether to come forward or not, he began to have second thoughts. Mr. Nolder made it sound like, oh, wow, that wasn't the right thing to do, was it? No, I guess it wasn't. But it wasn't the wrong thing either. It was a reasonable thing to do, given the situation. Does it mean he didn't see what he saw? Does it mean that he came in here and fabricated all that? Who's got the motive to do that? You got contrasting stories. One person says he's got a gun in his hand. The other says, I saw no gun. I saw nothing in his hands. My attention was drawn to him because he was dancing in the car and he was somewhat erratic. I thought at one moment that he was going to hit me. That's what was notable to me. Who's got the motivation to do this?
Councilwoman approach.
switch us over to the computer, please? Much to your relief, I'm almost done. There's a lot more I could say. Remember, back in voir dire, we talked about why did this happen? Why? And I said, you know, you may end up at the end of the case still asking that question, and it may still be unanswered for you, because that's not part of our obligation. We don't have to prove motive. But ladies and gentlemen, the defendant told us why this happened. I want to play it for you now.
He came out the street, gun in his hand, going to the side door, going in with a gun. You guys were pulling out? Yes, as I was pulling up.
Yeah, Joey asked for us to go.
Doing this. Who's in charge here?
I was one that was on the scene. I was one that was initiated.
Does that sound like someone who, like a objective, reasonable officer? No. He's going in the house with a gun. I had to stop him. There was nothing that he had done that indicated that he needed to be stopped. Especially when you eliminate his manufactured reason initially to be looking at it. No one saw a gun except the defendant until it was on the floor at 3996 Estates Place. No one, not Officer Rosser, no one. Why didn't they? Because it was in his holster. Ladies and gentlemen, consider all the evidence, evaluate it, and return a just verdict for Casey, who did nothing wrong, but had the terrible misfortune of crossing the path of Michael Jason Meade, an aggressive, arrogant, and remorseless officer who sat before you and told you what disturbed him wasn't taking an innocent life, but that he ruined his son's birthday.
Ladies and gentlemen, we're going to take our morning break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes.
All rise. You sit in their chair.
Let me give you a break.
On behalf of Mr. Meade, Your Honor.
All right, let's go to the jury.
All rise.
Everyone can have a seat. Ladies and gentlemen, I was looking around the gallery and I noticed a bunch of people wearing pink clothing. So I forgot to wish you a happy Valentine's Day to everyone. Any closing argument on behalf of the defense?
Yes, Your Honor. May I proceed?
Okay.
Thank you. May it please the court, Madam Court Reporter, Mr. Nolder, Jason, Ms. Stevens, prosecution team. Good morning, ladies and gentlemen of the jury.
Good morning.
First and foremost, I want to thank you. I want to thank you because you started this process by raising your right hand and taking an oath. And that oath was that you wouldn't draw any conclusions or make any assumptions or talk about the case or deal with the case until you go to deliberations. I've been busy, but I've tried to watch you, and I do believe you've kept that oath, and I thank you for that, because without you keeping that oath, and without you participating in civic duty, we wouldn't have the best criminal justice system in the world. So once again, I thank you. December 4th, 2020, ladies and gentlemen. It's a tragic day. It's a sad day. It's a tragedy that affects this courtroom, ladies and gentlemen. It affects this side of the courtroom. It affects this side of the courtroom. Somebody lost a son and a grandson, a brother, a friend on December 4th, 2020. Somebody has to deal with the sanctity of life and the preserving life versus the occupation. And December 4th, 2020, ladies and gentlemen, also will affect you if it hasn't already. You'll take a piece of that with you for the rest of your life. Everyone in this courtroom is going to take that with them and say, geez, December 4th, 2020 in the future. Okay? And own that because you're human beings. It affects people differently. The judge told you in the beginning we have a job to do, the different jobs associated with us. Your job's just getting ready to get started, the hard part. So in order to do that, ladies and gentlemen, I'm going to go over our case and our witnesses' credibility versus the government's case and the government's witnesses' credibility. And I'm going to draw the distinctions. I'm going to point out the consistency and corroboration, ladies and gentlemen, with our case and with Jason Meade. So let's start right there, okay? with Jason Meade. Tour in Iraq for Lima Company after 9/11. Honorable discharge. A pastor, an employee of the government in law enforcement for 17 years. Now, let's compare what Jason Meade perceived that day versus Jason Meade's statement that he gave 2 weeks after the December 4th, 2020, without seeing videotapes, without seeing body cameras, without seeing anything, because he gave his side of what he remembers. And let's compare that to the physical evidence, and let's compare that and see where there's corroboration and there's consistency. Remember in voir dire, we talked about credibility. Credibility. I talked to you about it, I said, yeah, if something's corroborated, if something's consistent, that makes it credible. Well, ladies and gentlemen, credibility and corroboration is not a coincidence. It just doesn't happen by luck. So let's go over the points that Jason Meade put out in his statement that have been corroborated and confirmed and occurred. First one, geez, I'm at the intersection, okay? And that's what this case is about, ladies and gentlemen. The interaction between my client and Mr. Goodson, from the interaction to the door. All the other stuff are distractions, ladies and gentlemen. So what does he tell you he sees at the intersection? I'm at the light, okay? I see a car coming. I see a person waving a gun. I see this. So what does he do, okay? So the issue is, do you believe more likely than not that my client saw a gun at that intersection at Carl and Ferris, okay? So how is that corroborated? Well, geez, he describes it in his statement, ladies and gentlemen, as an extended mag. I could see an extended magazine. Someone who's trained on arms, someone who's trained on those types of things, and they're trained, ladies and gentlemen, to look for the unexpected. They're leaving, they're clearing the scene. He's trained. He sees a guy waving a gun. That's not normal. Doesn't matter what time of day or anything, that's not normal. He watches that. So how is that confirmed, ladies and gentlemen, with physical evidence? There's a gun found at the scene, ladies and gentlemen. It's there, out on the body. The government confirmed it for us because they put the Casey gun owned and certified it and authenticated that in fact it was an extended magazine gun. Corroborated? Yes. Consistent? Yes. What does Jason Meade tell you, and in his statement, about what does he do when he sees it? He airs immediately to his team. He communicates with the only device he has with his walkie-talkie and tells them, I got a guy waving a gun, okay? He immediately does that. Now, is this corroborated and confirmed? Who? Yes, Deputy David Youngless. I'm at the Wendy's. I hear the call, guy with a gun. He says, Jay, is it our guy? No, it's not. Why? Because Jason Meade had dealings with Mr. Barber before. Okay? So, guy with a gun waving. Where are you? He gives a site. And we know that that happened, ladies and gentlemen. We know that it happened because they all respond. So, when Jason Meade puts in a statement that I aired over the walkie-talkie, a guy with a gun, right there, that defeats any indication that Mr. Merkel would say somehow that this was a cover-up. Because if it's a cover-up, then he must have started it at the intersection. That's how preposterous their case is. That's how desperate they are. That they would term that when he walks out to the light that it's a cover-up. Well, geez, let me think. I'm going to do this in the next 3 or 4 minutes, so I'm going to pretend to air that I saw someone waving a gun. Come on. And it's confirmed by Deputy Youngless. Jason Meade in his statement, the purpose of the statement is to say, this is what happened, this is what I saw. And you heard our Hughes, his purpose is to poke holes in that statement. In the statement, he says, when I saw the person at the end of the street, he had a gun in one hand and a bag in the other. Again, somehow Jason Meade is clairvoyant and knows. Now, again, how do we prove that? The government proved it for us with the picture of the bag. Jason Meade doesn't see any discovery. He has no evidence or anything like that when he writes this out. But he says 2 weeks after, I saw a bag in one hand and that in the other. But the cover-up started at the intersection. He says in his statement, ladies and gentlemen, that I did a U-turn. Is that confirmed? Yes, by the video. Does Jason Meade know when he writes a statement that there's a video? No, nobody does. He does a U-turn to pursue it. Do you think someone who's done a tour in Afghanistan for 7 months for the Lima Company is going to make up the fact that, oh, geez, yeah, I did a U-turn? No. How's it confirmed? Rosser confirms it. I'm sitting behind Jay. I see him turn. I think, oh, geez, he left something back at the scene. Happens sometimes. All right? But it's confirmed by a video and by Brian Rosser. The U-turn. Next. In his statement, he says, I stop and talk to Ryan Rosser. I stop quickly and talk to Ryan Rosser. He tells you that on the stand. How's that confirmed, ladies and gentlemen? By the video. You see him pause. Even Mr. Corne, they said, oh, that's where he paused. And he says, guy with a gun, guy with a gun. He communicates. He's got to go. He thinks Rosser, Jason tells you, he thinks Rosser hears this because he aired it over the marshal's channel. Ryan took his communication off. Okay, is that reasonable? Yeah. Does that make sense? Is it confirmation that he stopped and told something to Ryan Rosser? Yes. The video shows that, and Ryan Rosser. Confirmation. He tells in a statement, I point to the guy and say, there's the guy with the gun. Who confirms that? Ryan Rosser. Ryan Rosser says, yes, as I pulled up, get my stuff on, Jay, go, there's the guy with the gun. I look down. The guy looks at me. That's confirmed, ladies and gentlemen, and that's consistent. Consistency is not a coincidence. Corroboration is not a coincidence, ladies and gentlemen. Next, he yells. He says in a statement, I issue commands. I yell, drop the gun, show me your hands. U.S. Marshal, I yell multiple things, multiple times. How was that corroborated? 2 ways. Sheila Staniford. So somehow Sheila Staniford hears commands. Show me your hands, show me your hands. 3 times she says. And then she says, I heard shots. Mr. Merkel was, well, you heard the shots first, then the commands, right? She's like, no. Why would I lie? She heard commands and did that. And he has the audacity to get up here and say this was a cover-up? That, gee, somehow I'm going to pretend that there's a gun up at the scene. I'm going to pretend this. I'm going to do this. Then I'm going to pretend that I yell commands, but yet Sheila Staniford hears the commands. That's how desperate they are. Who else hears the commands? Ryan Rosser. He hears them as he's pulling up in the car, and he hears them. Can't tell exactly. He hears the commands. Then he hears the shots. Corroboration, confirmation. Let's go to another topic with regards to credibility, ladies and gentlemen. Credibility, okay? Remember Sergeant Stanley testified at the scene. There was an issue. He's like, hey, talks with the other detectives. We got an issue. We got a magazine that holds 30 on Jason's rifle. We only have six shell casings. Hey, have we missed another shell casing? What have we done? Well, let's ask Jason. Jason, how many do you start with? He says 29. That's a mathematical certainty. If there's 23 left in the magazine, and you start with 29, and guess what? There's 6 shell casings found. And he tells you what? And the people who testify with the weapon, if you pull that trigger on fully auto, you have no idea how many bullets come out. No idea how many bullets come out. One pull, it could be 3, it could be 4, it could be 5, it could be 10. It depends how long. So again, mathematical certainty, 1 + 1 = 2. There is no doubt. And again, you know he's telling the truth because He doesn't know what they're talking about. They ask him a question, hey, how many do you normally start in your magazine? He said 29. There's 23 left, and oh geez, this whole cover-up, there's 6 shell casings left, this whole cover-up. It's a mathematical certainty. Where else is he corroborated? By the physical evidence that doesn't lie. That's physical evidence. 23 bullets left, started with 29, there's 6 shell casings. What else is physical evidence? He tells you in his statement, and he tells you when he testifies where he was approximately when he had to fire his weapon. When the gun came back towards him, not turned all the way around like Mr. Goes, when the gun came back towards him, and there's an imminent threat facing him, an immediate threat facing him, he moves to the left, goes and fires, okay? So he tells you where he is, right? And he tells that in his statement. Geez, where are all the shell casings in those pictures, ladies and gentlemen? They're all to the right. Who confirms that every single person who testified about ejection weeks after? No access to any of this stuff. None. You heard Detective Hughes say no. Consistent with physical evidence. The government helps us and proves one on our own that we didn't even have to worry about. And that's when Mr. Schroyer started his cross-examination of my client saying, you said that a northbound car came through, right? In your statement. My client says yes. Hasn't seen the video, shows it. Mr. Schroyer goes, whoa, where's the northbound car? Jason goes, it just went by. A northbound car went by before Casey Goodson's car turned in there. Yes. Well, you can't see that on the video. They back up the video and you guys see the northbound car goes and Casey Goodson goes. They proved that for us. And that was in Jason Meade's statement. How many times do you think the 3 of these people have watched that video? How many times do you think they've gone back and forth? They've clipped it, they've cropped it, they've done it. They put their little circles on it. And Mr. Schroyer was even wrong about that. But yet Mr. Merkel stands up here and says, because Jason Meade said, I was wrong about that the car actually stopped in front of me versus it slowed down and continuous turn. I was wrong about that. Is it reasonable? They've had the video for 2-3 years, and he misses that. My client says, yeah, well, I asked him, why do you think you're mistaken? Well, I was focused on the gun. That's why he flinched when he went like this, when he turned to the side. I was focused on the gun. That's their big Perry Mason moment, ladies and gentlemen, that in a 10-page statement, that's the only inconsistency or only thing that's not exact to the video, exact to the physical evidence, from the time of the interaction at the scene until the doorway. Northbound. Jason didn't have the advantage of watching the video over and over, ladies and gentlemen, when he gave a statement. He didn't have that advantage. Mr. Merkel talks about the credibility of Mrs. Payne. We're not, no, absolutely. Mrs. Payne is credible, Sharon Payne. She's even so credible, ladies and gentlemen, that they asked her a question about, well, when he rides, you ride with him in the car, yes. Yeah. Does he have the gun? Yeah, he usually always has the gun with him. Well, it's uncomfortable for him when he keeps it in his holster, so he brings it out. Then they ask, well, does he ever point it? No, he never pointed. But she tells you, she's honest about, yeah, it's uncomfortable. That's why he doesn't ride with it. And then what do we have to do because they asked that type of question? Mr. Nolder has to get up here and show a picture of her grandson to someone who just testified, who they just played the 911 call to you, okay? And he has to say, who's this in the picture? That's Casey. Where is he? He's in a car. What's he doing? He has a gun. What's he doing with that gun? He's pointing it. That exhibit will be back there for you. That exhibit. So that's what they do, ladies and gentlemen. Do we think Miss Payne's not credible? No, we know she is. Because she's the one that tells you it's uncomfortable. He doesn't use it. He doesn't keep his gun in his holster in the car because it's uncomfortable. Want to have it both ways, ladies and gentlemen. They want to play on your emotions and play a 911 tape about what occurred after, ladies and gentlemen. Nothing during the intersection until the use of force was done. Nothing. Their whole closing, ladies and gentlemen, was about what was before and what was after. That's not the analysis of this case, ladies and gentlemen. How do we know that Jason's telling the truth? How do we know that he's credible? He was asked, did you put your siren on? No. He was asked, did you put your lights on? I don't know. I don't know. Ladies and gentlemen, someone who is lying tells you, I'm 99% sure I turned my lights on. We asked him, when you were at the scene, did you turn your lights when you were pursued? They asked him, did you turn your lights on when you were pursuing Casey Goodson? I don't know. Did you turn your siren on? No, I know I didn't turn my siren on. So, a lie, ladies and gentlemen, is, yeah, I'm 99% sure I turned my lights on. Oh yeah, I definitely turned my lights on. Yeah. And then you're shown that your lights weren't on. That's a lie. But when you say, I don't know, that's being honest. Watch the video, the full video, not the cropped one, the full video when Jason Meade goes towards the intersection. You'll see that it's 8 to 10 seconds, depending on how you count. Close your eyes when you go back in the jury room. 1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000, 7, 1,000, 8, 1,000. Open your eyes and imagine what you see to the left, to the center, to the right, in an intersection at Corne and Ferris. Okay, 8 to 10 seconds. Then write down what you saw without revealing anything. Okay? Everyone will have something a bit incorrect, but the basics will be there. The vantage point of my client was there for 8 to 10 seconds, observing Mr. Goodson's car, his attention directed to it, observing him go here, observing it going like this. Once again, they had it for 3 years and they get it wrong about what happens in the video, ladies and gentlemen. The cross-examination of my client was, geez, another Perry Mason moment. Geez, you said today, Mr. Meade, that Casey Goodson was running from you when he was at the car and went to the house. He was running back to the side house. Yeah, I said running, but in your statement you used moving quickly. There you go, moving quickly versus running. Then they go over and over with Ryan Rosser with regards to him describing how he was eluding or fleeing. Each of them saw what they saw and described, okay? But the issue is, the concept is, ladies and gentlemen, are they confirmed and corroborated that the guy was eluding them, evading them? There's the guy with a gun. Rosser says, I turn and he looks at me, and then he bolts, he flees. So does Jason Meade. Running versus moving quickly. Based on their training, ladies and gentlemen, every witness said this, if someone sees you and knows you're there and they leave, they're evading you. They're trying to elude you. Every police officer said that, ladies and gentlemen, because they're trained to look for that. This case isn't about whether he took his first step. When they asked Mr. Rosser, how did he take that first step? Did he run? It's a progression, ladies and gentlemen. We just went over, ladies and gentlemen, from the intersection to there, everything that was confirmed and corroborated on behalf of my client's testimony and statement. And yes, by the physical evidence. Now, let's go over talking about someone. Mr. Meade was consistent and credible and corroborated. Outside corroboration, not just himself. All right, now who in this trial could provide you with no corroboration? Who in this trial can give you neither consistency or confirmation? Who in this trial, geez, Mr. Corne, AKA Facebook poster, AKA the deleter, AKA I'm second place with 116 points on following Tamala Payne's we're friends on Facebook. That person. Let's look at him, ladies and gentlemen, and see what corroborates his testimony, if it's consistent with the physical evidence, as Mr. Merkel says. Well, he was unique because you got an instruction before he testified. That doesn't normally happen. There's a separation of witnesses. You got an instruction because he's watched the trial. He's watched Sheila Stedelberg. He's watched our client. He's watched the news. He's watched everything. It would be like taking someone in the back of the courtroom and plucking them in and say, hey, what'd you see that day? That's how desperate they are. That's their witness. They put that type of evidence on. Let's look at just his vantage point. Let's take it there. Forget the other stuff for a second. Let's just take his vantage point, okay? As he pulls up, he's in position 2. He's behind Jason Meade. Now, initially, he tells Mr. Merkel on February the 7th, oh yeah, I saw Casey Goodson's car. How can he use his name, Casey? I saw Casey Goodson's car on Carl. He doesn't tell that to the FBI. And he doesn't tell that to you. Mr. Nolder brought that out. Not them, Mr. Nolder. Then what happens is, he's, now, when you watch the video, use your common sense. Don't leave it in here. Take it back with you. You'll see that his car never actually stops. He kind of rolls, okay? I submit to you, using your common sense, that we have all approached the intersection rolling, and at some point, ladies and gentlemen, your attention's gotta be on the car in front of you, so you don't hit it. You gotta come to some type of almost stop. So I think it's reasonable to believe that you have to look at the car in front of you, right? Then look at his vantage point. Look at his vantage point, okay? And use the counter, okay? And again, your memory will be better than mine back there when you go, but use the counter. When I use the counter, from the time Casey Goodson's car turned to around the front of my client's car, 1/1002. Close your eyes. 1/1002. Imagine how fast that is. Look at the video. That's the vantage point, and that's the time that Chris Corne had to see in this situation. But it doesn't really matter, ladies and gentlemen, because he's watched everything else. He's watched everything. He told you he heard about the AirPods. So why would he say that he was dancing and stuff, Mr. Merkel wants to say? Because he heard that. He heard about the music. He saw it on the trial. Look at the 2 seconds. Now, the FBI shows him the video. Mr. Merkel, Mr. Short, Mr. Shaw interview him the day before. They don't show him the video, but the FBI does. Let's just listen to what he says in that video, or that audio tape, I'm sorry, in his tape recorded statement with the FBI. Well, put yourself in his shoes, ladies and gentlemen. We have that a lot. Put yourself in his shoes. The FBI is coming to interview you. Feel nervous? Yeah, geez, not every day you're interviewed by the FBI, right? What's he tell the FBI? Well, the guy made a wide turn. Okay. Look on that video, show me where the wide turn is, ladies and gentlemen. Now they're gonna talk about a brick wall, they're gonna talk, no. You can see the car turn, there's no wide turn. What else does he say? Oh geez, he almost hit me. You can't have it both ways. Either he makes a wide turn or he almost hits you. Because a wide turn, you're not gonna hit him. And again, 1/1002. This is what he's saying, okay? This is the time frame. Now, the best one is, when he tells the FBI, they ask him, well, how'd you know that these guys were law enforcement? He goes, well, because they had their lights on. He had his lights on. That's a problem at the intersection, because he doesn't. And they ask him, are you sure? He goes, I'm 99% sure that he had his lights on, because that's how I knew. Blue light, this light. Now, after meeting with the prosecutors, he changes that a little bit on the stand. Well, it was a brake light. No. He tells the FBI he's 99% sure that the only way I knew they were law enforcement is because Jason Meade had his lights on, the ones above, the ones on the side, and stuff like this. He even talks about that in the interview. Well, are you sure? Then they show him the video. No lights on. And he goes, well, maybe during the U-turn. No. That's their corroboration. That's their witness. He must have only seen the part of the trial where Mr. Merkel showed multiple times of Jason putting lights on at the end. At the end of the thing, after medics are there and everything like that. So, of course, yeah, his lights are on. That's why he says it, ladies and gentlemen. He's told about the pains and perjury of talking to the FBI, and you need to be truthful. And the very last question is there anything else that you think is important? Anything else that you think? Do you have any contact with the family? Anything else important? Chris Corne says, nope. Nope. He doesn't tell him that he posts directly instant messages to Malapane 4 times. He doesn't tell him that he comments, likes, loves, things of that nature. Thumbs up, caring emojis. He doesn't tell the FBI that. He doesn't tell the FBI that he's at 116 points. He's almost a top point getter for 1 week. This is the week of January 28th. That's 3 days before this trial even ever started with evidence. Opening statements were on January 31st, ladies and gentlemen. He's posting and responding to their site on January 28th, 29th, the 30th. He keeps posting the 31st, the 1st, the 2nd, the 3rd. He's ahead of one of the other Payne family members. He's in second place at 116. Now, I don't think I need to say that to the federal government. But that's reasonable, Mr. Merkel says. That's reasonable that he didn't tell them that. That's not doing the right thing, ladies and gentlemen. That's not doing the right thing. Instead, what does he do, ladies and gentlemen? They interview him on the 7th, the prosecutions. He's interviewed by the FBI on the 8th, and what does he do on the 9th, he tells you? Yeah, I'm going to delete everything. I'm going to delete everything. That's doing the right thing. People don't delete things who are transparent. You don't delete something unless it's a problem. You don't delete something unless you're making it up. You don't delete that. You don't delete stuff if you want to be the 15-minute fame. You don't. But now we know why he deleted it, ladies and gentlemen. And again, this is their witness, contradicting himself. He tells Mr. Nolder, well, I guess I shouldn't have done that. Really? Do the right thing. Really? Let's also look what he says. Now, this gets into the details, okay? Let's take his statement apart. His statement to the 3 prosecutors and his statement to the FBI. Number 1, they said, well, can you describe him? Describe what he looked like. Well, first he says it's a female. And he says, oh, split second. Keep track of the split seconds. Then he says, yes, the person had an afro. You know that Mr. Merkel just showed you that he had a do-rag on. You know from the pictures that he had a hood on. You know that a do-rag can't show an afro. 0 for 1 he is. That's in the first interview. In the second interview, the FBI asked him, well, describe him to us. Well, he had a ponytail. Didn't have a ponytail. Ladies and gentlemen, Chris Corne can't even corroborate himself. He can't even be consistent himself from one day to the next because that's not true. First it's an afro, then it's a ponytail. And you guys know from the evidence, he had a do-rag on. You can't see that. But Chris Corne needs you to believe that. He's got to add those things in there, ladies and gentlemen, because he's doing the right thing. They know. They know. Now, did they ask him about social media? No. Did the FBI ask him about social media? No. We did. And he knows coming to the deposition on Monday at our office that he's already deleted this stuff. He knows. They're there. They know how biased he is, but they still put him on, ladies and gentlemen, because their case is terrible. Desperate. He says 99% 3 times in the interviews. The first time is with the lights. The second time is I'm 99% sure that I came back out of states. Oh, really? Tells that to Mr. Merkel, tells that to the FBI. The FBI then shows him, and guess what? He's wrong again. So far he's used 99% 2 times, and he's been wrong about both of them. So even 99%. Likes, cares, emojis. Now, what was really striking, ladies and gentlemen, was on the cross-examination with Mr. Nolder, okay? This is using your common sense and the credibility of a witness that an instruction was given to you is he says, man, yeah, when I was at the park down on estates for about 10 minutes, give or take some. And he goes, then I looked and I saw this person who scared or spooked me. Ladies and gentlemen, we've all been in that situation where you get scared or startled or you get spooked by something. And what do? You then look at it. You then describe it. You then go, oh, geez, that's elated. Mr. Nolder asked him, can you tell me what she looked like? No. Can you tell me what she had on? No. Can you tell me where she was in the house? No. Can you tell me where the car is? No. He can give you no details about that. Now, but the government wants you to believe that, oh, he was dancing and singing and stuff like this, and could see all that stuff in 1002 with this. What else does he say? Well, geez, there was one hand on the wheel. No, there was no hands on the wheel. There were both hands on the wheel. One hand here. Multiple. But he can give you nothing about the person who scared him, and he was looking at them, and he realized, yeah, that she's taping me. And he's looking directly at them. Zero information. Ladies and gentlemen, the reason we asked him about the post on December 18th of 2020, this is 2 weeks after the incident, 2 weeks. The reason we asked him about that is because it's important. And the reason we asked him about that, ladies and gentlemen, in Mr. Nolder's last question, ladies and gentlemen, his last question to him, tell me what, in verbatim, what the post read. Okay? I said I was there. I was behind Jason Meade, and I saw the victim come by, and I said I followed down the street. I didn't see anything. That's what he posted on December 18th of 2020. That's what he posted. And he deleted that because he's trying to deceive you, and he's trying to hide stuff. And they put him on. And they know it. And Mr. Merkel says that, I think he acted reasonably. Well, if he acted reasonably, ladies and gentlemen, then we've proven more likely than not, we've proven beyond a shadow of a doubt that Jason Meade acted reasonably. Mr. Merkel gets up here and said, I think he acted reasonably. Very important, ladies and gentlemen, are you going to rely upon the word of Christopher Corne for a surgery for a child or care for an elderly parent? Because that's proof beyond a reasonable doubt, ladies and gentlemen. Is that the type of evidence you're going to rely upon that's not corroborated, inconsistent, made up? He can't even get it straight after watching the trial, ladies and gentlemen. Is that what you're going to rely upon in the most important of your fellows? Very important in this case, ladies and gentlemen, what's in the jury instructions versus what's not in the jury instructions. So let's change gear with that. What's in the jury instructions, ladies and gentlemen, that you have and you read is you only are to judge Casey Goodson's conduct perceived by my client from the time of the intersection to the shooting. That's conduct. There will be no whys in there, ladies and gentlemen. There will be, why did Casey do this? Why didn't he abide by the commands? Why didn't he stop after the commands? Why didn't he do something? And Mr. Merkel knows that. He just got up here and told you the whys of the case, like in voir dire. This isn't about why somebody did something. This is about actions perceived, things that are looked at in my client's shoes. They talk about in their opening the whys and stuff like that. There is nothing in the whys, ladies and gentlemen. It's all a distraction, ladies and gentlemen. It does everything that he talked about in his closing was before. The dentist, the subway, the commercial driver's license. None of that is known to Jason Meade. This case is analyzed on what Jason Meade saw at that intersection there to the house. That's all distraction because that's all they have, ladies and gentlemen. There's no reasons why a person flees. It's if you see the act of evading. We talked in voir dire about no shoulda, coulda, woulda. I counted 6 times, ladies and gentlemen, that Mr. Merkel said the reasonable officer should have done or could have done in his closing. Well, ladies and gentlemen, the actual jury instruction, you'll have it back there on page 8, says the relevant legal consideration is not what the defendant officer should have known or should have done, but whether the reasonable police officer placed in his shoes could have believed about the situational need to use deadly force, could have believed. And they still keep doing it. The experts both agreed you can't do shoulda, coulda, woulda. We talked about that in voir dire. And they keep doing it, even in their closing. Kevin Davis puts you inside of Jason Meade's shoes. Jason Meade puts you inside of his shoes in his testimony, ladies and gentlemen. Nothing in the jury instructions will say you're to do it from Casey Goodson's perspective. What was his intent? What was this? What was this? And that's all their closing argument was. Oh, geez, 6 shots. How could safety on how could you? No. That's not the legal consideration. The judge told you in there, you can't use hindsight. That's all Mr. Schroyer did with Jason Meade's cross. You didn't tell Ryan Rosser to put a siren on, right? You didn't tell Ryan Rosser to get on the loudspeaker. You didn't do this, you didn't do that. You didn't wait to verify a plate, did you? No, there's no leads in his car, and verifying the plate, it would come back to a female, not a male who's driving it, who's parked the wrong way, who runs to, not to the front of the house, but the side of the house. You didn't do this, you didn't do that. That's their whole cross, ladies and gentlemen. What you also won't find in the jury instructions, ladies and gentlemen, most importantly, that their expert opined on forever, are tactics. You won't find anything in there about tactics, ladies and gentlemen. The word tactic will not appear. You know what else won't appear? Reasonably accepted police practices. Because the judge gives you the law here. You have the law. You have the law on justification and the calculus of reasonableness. You know what's not in the jury instructions, ladies and gentlemen, is what Jason Meade did not say. Did not say. Remember when Mr. Schroyer got up here in opening and he said, silence is powerful. Silence is powerful. And they try to deceive you with the last clip. Mr. Meade's answer, ladies and gentlemen, but for us, we played the whole tape. They played a clip. The question that was asked, that was brought out from the Minerva Park officer, the question that was asked on his body camera was, what was the call? How did I miss the call? That's the question Jason's trying to answer to Officer Phillips. They don't bring in Officer Phillips. That's the question that was trying to answer. We exposed that. We shed light on that. The question that was asked is, how did I miss the call? What was the call? The call was continuously, and he told you, he radioed it at the intersection, a guy with a gun, he radioed it as he was going down States. That's what the call was. Guy with a gun, waving a gun, pointing a gun. The question wasn't, why did you fire your weapon? That's not the question. But that's how desperate they are, ladies and gentlemen, that they have to just give you a clip and say, here's what Jason Meade's answer was, and they don't even give you the question. Mr. Merkel talked about playing fair in voir dire, playing fair. Playing fair, ladies and gentlemen, is when a coroner, who's a forensic pathologist, who's certified, who testified, it is impossible to say which shot was first. Impossible. He gets up here and contradicts with some theory that he believes the first 3 shots were these. It's impossible, the coroner said. But they just keep going. Ladies and gentlemen, Jason Meade told you once he found out that the person who was placed in a situation, who put the gun back towards him, who he shot, was someone's nephew in the house. He told him how that made him feel. He told you that people react differently, ladies and gentlemen, when they're in use of force. Some people throw up. He told you because he just learned that it was someone's nephew in the house, he thought about his family and potentially lots of his family, and that he just had to shoot someone. And he has to tell his son on his birthday that I was placed in a situation where I had to make a split-second decision. And how's that going to affect my son? Not, geez, oh my God, I can't believe this happened. And especially on my son's birthday. No. But that's how they twist it. What definitely is in the jury instructions, and you heard it already, is the testimony of one witness, if believed by you, is sufficient to prove, ladies and gentlemen, any disputed fact. testimony of you, okay? Mr. Merkel's right. There's only one person who saw the gun came back, and that was my client, okay? But that happens in our society, all right? Under their theory, one of us was walking down an alley and we got robbed, and there was no cameras, no anybody there to see it getting robbed, but I pick out the person and I say to the police, that's the person. That wouldn't be good enough for them because there's no other witness to the robbery. One witness is believed by you, ladies and gentlemen, that the gun come back. He's the only witness that was there in that vicinity when the gun came back. Yes. But that doesn't make it any less credible, ladies and gentlemen. That's why that jury instruction's in there. Ladies and gentlemen, our case was consistent and was corroborated in every aspect. The fairy tale that they want to tell you about where the gun was, that there was no gun at the intersection, there was no gun at that type of stuff. Ladies and gentlemen, they've put nothing in the record. That's closing arguments. They've put nothing in the record disputing that the gun came back. Zero. Not one witness said, in my belief, the gun couldn't have come back. Zero. Nothing contradicts that. Just their creative fantasy arguments. Now, let's look at that. Geez, the holster, okay? Two people said, Rosser said, I used that holster. It doesn't come out. Could come out, might not come out. Hughes says yes. It doesn't matter, ladies and gentlemen, because of physical evidence. There is no blood on the holster. There is nothing there. And think about the clothing that was worn. Okay? There's blood on the gun. Think about the clothing that was worn. Underwear, shorts, pants, okay? A t-shirt, sweatshirt. You see the picture of the sweatshirt and think, the sweatshirt's down here. If the gun, about whether or not, and my client did see the gun turn back towards him. That's a distraction, ladies and gentlemen. How do we get here, ladies and gentlemen? How do we get in this situation? Because the government starts with a premise and works backwards. What do I mean by that? Ms. Stevens told you in her opening that they started from a premise and worked backwards. 6 shots in the back and silence. And Casey Goodson's not a threat. That's what they told that they were going to prove to you, okay? 6 shots in the back, silence, and Casey Goodson wasn't a threat. What happens when you start from a premise and you work backwards, ladies and gentlemen, is you hire an expert after the fact who doesn't know Ohio law, who doesn't tell you definitions, all right? And you indict someone for 3 competing theories, all right? And then what happens in your case is your own witnesses, ladies and gentlemen, contradict your theory of the case. Your own witnesses contradict your theory of the case. So that's their theory, right? He's not a threat, silence, 6 shots, 6 shots, 6 shots, 6 shots. All right, well, who's the first group that contradicts him? Officer Rippey, Detective Williams, Detective Croom. They all tell you, if you see someone waving a gun, you have a lawful authority to pursue. You must pursue. You must investigate. They all tell you that if you see someone with a gun eluding you, you have to go forward. You have to go forward. They all tell you that their actions as an officer are based on whatever the suspect's actions are. You have to react to the suspect's actions, okay? All 3 of them say that. All 3 of them say, can someone be a threat if their back is facing you and they have a gun? Yes. They're not a deadly threat yet, but yes. And they all told you after Mr. Merkel asked questions, if the gun came back, they even interrupted, I would shoot. They all told you that based on their training, if the gun came back, they would shoot. That goes against theirs. The second person, ladies and gentlemen, you heard them tell about how fast someone can turn. They all said, if someone has a gun and their back is towards you, are they still a threat? Yes, because of the quickness, because of the sudden turns. That's their witnesses. The next one, ladies and gentlemen, is the coroner, okay, Dr. Shepler. Now again, the audacity to say to even give you an idea of which shots are the first goes against 100% of what she testified to. It's impossible, and she's a forensic pathologist. If anyone would know, she would, and it's impossible. Now, it's not that complicated, ladies and gentlemen. You don't need a big demonstration. I asked the doctor, if you're facing this way, and she pointed out the wounds, 1, 2, 2 up here, 2 over here. Those entrance wounds were all what? Back to front, right to left, and upward, correct? So if the body's positioned, doctor, the entrance wounds are consistent with the bullets coming this way. She said, yes. Doctor, You don't know the position at the time, do you? She has no idea, access to discover anything like that. No. You have no idea how the body was positioned. Correct. Doctor, if the body was turned this way, and the same wounds, the same entrance wounds, 1, 2, 3, 4, 5, 6, the same entrance wounds, ladies and gentlemen, was this way, would that be consistent from the bullets coming this way? Yes, it would be consistent. It's that simple, ladies and gentlemen. And think about it. She doesn't have Jason Meade's statement. She doesn't have anything like that. She has not. It's that simple. Their own witness contradicts their theory of the case. Right to left, back to front, upward. Using your common sense, that kind of matches with what Jason Meade says in his statement, but somehow there's a cover-up. Now the cover-up involves Dr. Shepler and my client on the positioning of the body. My client told you when he was facing away, could you see the gun? No. Did my client shoot then? No, because he couldn't see the gun. But when the body turned, and my client never said he turned and faced him. My client said he turned. The gun came towards me. Using your common sense, ladies and gentlemen. And don't get distracted by impossibilities. Their own expert, ladies and gentlemen, Mr. Stoughton. They're his words, ladies and gentlemen. They're his words. And his words, ladies and gentlemen, are, if Mr. Goodson did turn and point a firearm, Deputy Meade's decision to shoot was appropriate, reasonable, and consistent with generally accepted police practices. They're his words. He agrees in his report. Now, what does he tell you? But he has to testify for however long, let's see, $3.85 an hour. He's got between 40 and 50 hours, so I did 45. Then he's got 8 hours last week plus travel, so I did 8, 9. Then he's got 8 hours yesterday and travel, that and that. So that's about 70 hours. And you times that by 385, and it's $26,950 to tell you that. He's not an expert in Ohio, never trained anybody in Ohio, doesn't have any police training in Ohio. Compare that with Kevin Davis, 33 years as a police officer in Ohio, OPATA certified, trainer of the year. Thousands of people he's trained on use of force and deadly use of force. Kevin Davis definitely knows the definition of deadly force in Ohio. This guy comes from another state and says, sorry, I'm in Ohio, can't do it. I don't know the Ohio definition. You don't take the time to respond to my partner. You don't take the time to look up the definition of deadly force in Ohio. That's their expert. Not me. No, that's not what I can't do that. I can't do that. He was retained after the indictment, ladies and gentlemen. And he gives you no evidence contrary. They were waiting for it. Oh, I have this, I have something from the corner, I have this picture. He goes, so there's a factual dispute. His big factual dispute is Jason Meade didn't stop. Jason Meade said Casey Goodson stopped at the intersection to let the car go by, and he didn't stop. Whoa! That means the gun didn't come back. Jason Meade, no evidence contrary. That's what happens when you start from a premise and you work backwards. What also happens, ladies and gentlemen, is you stand up in closing like Mr. Schroyer did, and you talk about locking the car. You talk about, Casey Goodson got out of the car and locked the car. That's why they ask the questions about, hey, the car can't lock remotely to the family members. The keys did that. What shred or scintilla of evidence did they put forth saying that Casey Goodson locked the car when he got out? None. That's how they do it. That's how they roll. They put 0 up there in it. What happens when you start with a premise and you work backwards? You have 3 competing theories: reckless, knowingly, purposefully. I'm not sure, ladies and gentlemen, how you can have a reckless thought and a purposeful thought, intent, because they have to prove the intent. Those are the 3 elements of in play here, ladies and gentlemen. The 3 elements. Let's look at recklessness. Was Jason Meade reckless at the scene, at the intersection? No. Did he fire his weapon there? No. Did Jason Meade fire his weapon when he saw Casey Goodson at the end of the street? No. That would be reckless. Did Jason Meade fire when Casey Goodson was going away from him and he was pursuing him? No. That would be reckless. They have proven beyond a reasonable doubt, ladies and gentlemen, that there's 3 holes in the door. They have proven beyond a reasonable doubt that the floor plan of the panes. They have proven, but they've also proven, ladies and gentlemen, is that this is a sad case. It's a tragedy. Goes without saying, right? We talked about this in voir dire. It's going to affect you. Absolutely. And what did they do? They, ladies and gentlemen, they first start, and you're told in the jury instructions, ladies and gentlemen, that you can't use sympathy. Okay, good luck. That's what you're tasked. You're tasked to be a clinician back there. Who was a clinician? The coroner. She was almost giddy going through the past and the bulls and stuff, but what do they do? First, they start with a picture of the front and back, entrance wounds and exit wounds. And then what do? They go over all 6 entrance wounds and all 3 exit wounds, and the fragments and everything like that. Okay, people start to get emotional. Okay. Then what do? They do the side view. 6 entrance, 3 exits. And they do the exact same thing over again and over again. People start crying in the courtroom, of course. It affects you, of course. Then what do? They take it to another level and they put the pictures, the more people start getting more upset. And you actually see the big hole and the grays and all that. And they have the coroner go through every single path that the bullet, every vital organ that it had. Ladies and gentlemen, they do that, but no one's contesting the cause of death here. No one's contesting the manner of death. You heard us. We still have it stipulated. The person at the scene is the same person who did the autopsy on it. It's the same person that died as a result of gunshots. No one's contesting it. But that's all they have, ladies and gentlemen. That's all they have. And they keep doing it, and then they do it again today. Their own trajectory expert contradicts their case and their theory, ladies and gentlemen. Ms. Creela, she can't tell you the position of the body. She can't tell you the position of the door. She can tell you it wasn't at 0, and she can tell you it wasn't all the way open. And that's all she can tell you. And this is the type of evidence that they put forth, that you're supposed to rely upon the most important of your own. They tell you, we settled on 45. We did an arbitrary thing of 45 degrees with the screen door. She has no idea. It could be 1, 2, 3, 4, 5, 6, all the way, it could be all the way up to 89. Yes. So what does the government do? They have this picture that they give to Professor Stoughton, who now somehow is a trajectory expert. May I have the Elmo, please? So this picture, right? This picture, ladies and gentlemen, is done with a door at 45-degree angle, arbitrarily put. And look at the trajectory here when you go backwards. That would mean that it was here, okay? Here along these lines. Well, this is the fence. So that means the shell casings would now be over here to the right. That means Jason Meade must have been inside the fence area when he shot. And you know that's not true from Rosser. You know that's not true. So ladies and gentlemen, I don't know why they give it to Professor Stoughton, but that, even at 45 degrees, it can't happen that way. And that's their proof, ladies and gentlemen. This is what happens, ladies and gentlemen, when you start from a premise and you work backwards. Jason Meade told you that he thought he was complying when he shrugged his shoulders down, and Jason stopped going forward. He thought he was complying, and then he turned. He can't tell you which foot was up, which position, couldn't see this, couldn't see it, didn't see the keys, didn't see, no. He could only tell you that he couldn't see his hands when his back was to him, but when he came back, 3 holes in the door. Focus on that door. That's the case. Caleb Worley, what did he testify to? The gun guy, likes his job, good at it. Caleb Worley, right? Caleb Worley, what is that? What do they do? They have him parade that scary weapon, that big weapon, how much bigger it is than the handgun. That's the rifle that he's issued on SWAT team. Their expert was issued the same thing when he was for the Tallahassee Police Department. But what do? They parade it in front of you. Slowly. Click, click, click. That's what they do to you. For 55 minutes, he testifies about that type of stuff. Because it's got a sight. Because it does this, it does that. It's the issued rifle. What did he really testify to, ladies and gentlemen? This is where it really gets difficult for the government. This is what he really testified to, ladies and gentlemen, is that the 6 shell casings found at the scene all came from the rifle. Whoa! Alert, alert. We acknowledge that. That any of the projectiles that were found at the scene or fragments most likely did come from the weapon. Yes. No one's saying it didn't. But they put them up there for the effect of that. Whew. He had such an advantage with that rifle. But what did he really say, ladies and gentlemen? Ms. Stevens cross-examined him. What did he really say? He said, safety. You're trained. You never point a gun at something unless you intend to shoot. And that's how law enforcement officers are trained to respond. You never point at something unless you're going to shoot. And again, it's a distraction. It doesn't matter, ladies and gentlemen, to Mr. Worley, if it's a toy gun, if the gun is unloaded, if the gun doesn't work, or if the safety's on. You would not be able to tell that at 10 to 15 feet apart because that wasn't anything known to Jason Meade at the time, but they've got to throw that out there for you. They've got to try to deceive you on that. Caleb Worley said, Ms. Stevens, I wouldn't be able to see that in any bit. It doesn't matter. That's why you have instructions in there about mistaken, about those types of things. An officer can be mistaken, whether it's a toy gun, fake gun, no gun even. A possession of the gun is irrelevant. You never point a gun at something unless you intend to shoot it. They have a dog and pony show, ladies and gentlemen. They rap with sympathy, they rap with a scary gun, and they want you to fall for that, ladies and gentlemen. But they don't even take the extra steps, ladies and gentlemen. What do they not do? What do they not do in their investigations? No one in their investigation, Ms. Creela said, yeah, I would have really liked a rifle. I would have tested myself to do the ejection pattern. Send the rifle? No. Do they send to Detective Howe the AirPods to see if they're even working, to see if they're paired one off, one? They don't send anything. Do they ask Corne, them, or the FBI about social medias? Absolutely not, because they don't want to know. Do they go and find the picture that's missing from there with the trajectory? No, because they don't want to do those things. You don't distract unless you have something to hide. That's what they do, ladies and gentlemen. Ladies and gentlemen, this case is about the whole case and the truth of the case. This case is about the whole picture. Who gave you the whole picture? Who shined a light on the entire case? We did. Our case in chief. You would have never heard from Sheila Staniford had we not called her. You would never have heard that she corroborated our client by saying, I heard the commands 3 times, then I heard the shots. They kept her from you. They knew what she said. They had the tape recording, but it doesn't fit their theory. We called her. We shined a light on the whole picture. If we didn't call Ryan Rosser, ladies and gentlemen, you wouldn't have corroboration about many things. First of all, that he stopped and told me a guy's got a gun. Do you think Ryan Rosser believed Jason Meade when Jason Meade said guy's got a gun? Absolutely. That's why he did the U-turn. We gotta go, guy's got a gun. Again, what does Ryan Rosser tell you? At first I thought maybe it was Barber, he came back or something like that. But then when we got up there, and went past the Barber residence, I realized it wasn't Barber. What does he corroborate next, ladies and gentlemen? That he pointed him out and then the person fled. Ryan Rosser corroborates that. We called Ryan Rosser. As he pulls up, what does Ryan Rosser hear? Show me your hands, show me your hands. We called Ryan Rosser. We shed the light. You would never have heard from them if we didn't call them. There's no recordings of it. There's no body-worn camera. No, the U.S. Marshals doesn't allow it. How do we corroborate that if we don't call David Youngless, you will never hear that Jason aired what he aired at the time he saw it. Their theory, ladies and gentlemen, is so outlandish. They think someone with Jason Meade's training, someone who's honorable discharge from the Marines, who You don't get honorable discharge from the Marines if you delete stuff. You don't get it. You don't get honorable discharge if you lie. But he airs it and says it, but their theory is he didn't see it. It's a cover-up. You don't hear the actual question Officer Phillips asked Jason unless we play the whole clip. You don't hear it. The question was, what was the call? How'd I miss the call? Not, why did you fire your weapon? Ladies and gentlemen, a reasonable doubt is doubt based on reason and common sense. In this case, the state's own evidence, ladies and gentlemen, and the conclusions they ask you to make insult your common sense. It's insulting. Our case is real simple, real straightforward. Two things we have to prove. Number one, more likely than not, a smidge over 50%. Number one, more likely than not, was Jason Meade placed in a situation in which he had believed there was an immediate threat when the gun came back, and he had to use lethal force. Number one, did he perceive that? Did he believe that? We've proven to you that more likely than not. Number two, we have to show that from the interactions, from the time he saw that gun to use deadly force is reasonable based on the totality of the circumstances that he observed. And then you put a reasonable police officer in his shoes. And is that something that a reasonable police officer could believe as well to use deadly force? That's what we have to prove, more likely than not. You can find that they didn't meet their burden, and your analysis stops. You can find they don't meet their burden of proof beyond a reasonable doubt, your analysis stops. If you find that they did meet their burden, then you have to go to ours, more likely than not. If you find that we met ours, and you find that they met theirs, it must be not guilty. Our burden, even though it's lower, trumps theirs. That's just the law, ladies and gentlemen. You might be sad about it, you might not agree with it, that's the way the law works. Because officers are afforded that type of deference because of the danger of their jobs. So we have to refer you in the jury instructions when you go back there to the calculus of reasonableness. The calculus of reasonableness. Here's what's in the jury instructions. The Graham factors. We talked about them on voir dire. Mr. Davis talked about them. Stoughton talked about them. But the Graham factors. Number one, severity of crime at issue. Waving a gun, pointing a gun, running away through a neighborhood, everyone testified is a severe crime. Is it more likely than not the severity of the crime? Yes, we've proven that factor more likely than not. All law enforcement officers said that that's a dangerous situation. We don't have to prove that that's a deadly threat right then, ladies and gentlemen, but we have to prove more likely than not that the waving of a gun and fleeing with a gun is dangerous. Number two, whether the suspect posed an immediate threat, okay? And there is no higher threat, ladies and gentlemen, than when an officer's staring down the barrel of a gun. There is no higher threat. And there is nothing more that's immediate or imminent than that, ladies and gentlemen. And we have proven that more likely than not. Another Graham factor you'll see in there was the suspect attempting to evade. More likely than not, based on what Ryan Rosser said and based on what Jason Meade said, was it more likely than not that he was attempting to evade? Yes. They both testified that Jason had his stuff on. There's the guy. He turned and looked at us, and he fled. That's what they observed. That's what they perceived. And a reasonable officer in those shoes would perceive that as evading as well, ladies and gentlemen. The next one, you're to consider situations with furtive gestures or sudden turns. Do we have that here? Yes. There's a sudden turn with the gun. That's when he sees the gun. Your next Graham factor you're to consider is, did he ignore commands? Yes. You heard Sheila Staniford say that she heard the commands. You heard Jason Meade say he told them, and you heard Ryan Rosser say you hear him. You're not going to hear it, see in there, why did he ignore the commands? That's not the analysis. And I know that that's hard because this is such a devastating case. But that's not the analysis. Based on the observations, did the person not listen to commands? More likely than not, yes. Commands were given, he never stopped. Commands were yelled by someone in the Marines, by someone in 18 years of law enforcement. They weren't talked. The next factor that you'll read in the jury instructions is, was the suspect possibly armed. Again, more likely than not, 100%. Whether this occurred during a chase, yes, more likely than not. The next one is the duration of the confrontation. The duration of the confrontation is important because how fast things change. They go from up in the intersection to this. Once he ran with the gun to an unknown place, an unknown address, no matter what someone says, police are trained to expect the unexpected. Police have to believe that there's nefarious intent going on. Police have to believe that. That's how they're trained, because it's not normal for someone to be waving and pointing a gun in an intersection, to then be eluding police. That's not normal activity. You don't just go, hey, I'm here to talk to the guy about, no. But that's the distraction they want you to have. What's not in there is tactics, ladies and gentlemen. What's not in there is generally accepted practices. This case is about what happened from the time of that incident to the shooting in the doorway. And my client told you, I didn't shoot when he was running. I didn't shoot. He wasn't reckless. He wasn't. He was placed in every officer's nightmare situation. And he had to respond. We started off closing, ladies and gentlemen, talking about the tragedies in the two families. Those tragedies will never go away. No verdict that you give back in this case will ever take those tragedies away. There is no verdict, ladies and gentlemen, that will bring Casey Goodson back. There's not. There is no burden that will heal both sides of this courtroom, ladies and gentlemen. There is no verdict. There's no power to do that. Ladies and gentlemen, you do have the power, though. You do have the power to prevent a third tragedy. And a third tragedy would be to rely upon evidence that they put forth, either in their direct or their case and rebuttal, ladies and gentlemen, or their cross-examination. That would be the tragedy, ladies and gentlemen, if you allowed that, because we have proven our case more likely than not, that our client was faced with an imminent, immediate threat, and that he had to use lethal force. And we have proven that more likely than that, ladies and gentlemen. I wish you good luck in your deliberations and Godspeed, and I thank you for your time. Thank you.
Councilwoman Approach? How are you guys holding up?
Good.
You want to keep going forward, or you want to break?
Keep going.
Yeah, keep going.
All right.
Hey.
Does anyone need a bathroom break or anything? Okay, let's take a 15-minute break. Oh, hold on. not discuss this case among yourselves. Do not permit anyone to discuss it with you in the presence of the jury. Everyone can have a seat. Any rebuttal closing on behalf of the state of Ohio?
Good afternoon, everyone. Well, it's to me, it's amazing how quickly the burden shifts. You'll have the instructions. You understand that, as when Mr. Merkel was up here, we had the initial burden to show the elements of the offenses that are charged, 1, 2, or all 3 of them. Then, if you agree with those, which I don't think anybody disagrees, that Jason Meade was the one that did the shooting, the defendant, that he shot Casey Goodson. Casey Goodson died as a result of these injuries. So the shift shifts to them. Mr. Collins gets up here, it's like, well, the state didn't do this, the state didn't do that, the state didn't call this witness. Well, guess what? We don't have to. It's their burden. If they want to call them, they call them, because they're the ones that have to prove it to you, not us. It's their burden of preponderance of the evidence. Now, the standard is what a reasonable officer placed in the shoes of the defendant does not mean that you believe the defendant's subjective belief, or that you have to take it, or that it's true, or that it's even reasonable. You got the instruction on credibility. So you're the ones that are going to decide whether it was reasonable, whether it was true. Also, Mr. Collins brings up, it's not 20/20 hindsight. You mentioned 20/20 hindsight. It is not 20/20 hindsight to evaluate his actions from an objectively reasonable officer's standard. Because what you're doing is you're going to evaluate his tactics. You're going to evaluate his decisions. You're going to evaluate his actions. Because all these go towards his mental state, his demeanor, and his credibility. Throws everything to the wind, doesn't follow his training, police practice as to what he's supposed to do, and tosses it off to the side. You're going to make that decision as to how that affects his credibility. Tactics. Now, the evidence which has shown that the defendant was overly aggressive throughout all objectively reasonable policing tactics. He can't be believed due to his rapidly evolving story and his excuses covering up his unjustified shooting of Casey. And he spoke to some of that. I want you to think back to the very first question I asked him. He did acknowledge the importance that reports are accurate, reliable, and complete. After all, he's a law enforcement officer. That's part of being a law enforcement officer, is to be accurate, reliable, and complete. He knew when he made his 10-page statement, weeks following the shooting, that it needed to be, and he admitted, accurate, reliable, and complete. Now, so what's happened? Mr. Collins brings up the intersection in his statement at the intersection. And he's trying to say that, well, he was all 3 of those things, but he wasn't. And I'm going to explain to you why this is important at the intersection. He's right. Didn't know about the video. This is when he makes his 10-page statement. He was very specific and expressed details, trying to express that how he was able to see Casey Goodson's vehicle, how he was able to see what he's going to put in this report after the shooting, what he's going to put in this report to make him more credible. So what's he say? What's he say? I'm stopped at the intersection. Okay. He just pulled up. This video verifies that. I was 10 feet away when Casey Goodson's car stopped in the middle of the intersection. Why would he do that? Oh, I can see, observe what I'm going to tell him the rest of the story. I've got the best view. What's next? Well, he stops. And the reason he stopped was because why? Oh, there's a northbound car coming. That's why he stopped, sitting there while I'm looking straight ahead, 10 feet away, looking at him, waiting for the northbound car to come. So what's he put in his statement then? I could see him then pointing the gun at the northbound car, watching it go through the intersection. Now, ladies and gentlemen, these are material specific things from a law enforcement officer made a few weeks after, who's trained to observe. So what's the next thing he says? He's trying to create a scenario where Casey was threatening another vehicle. Now, mind you, he's the only one that sees this. Mind you, at least in his mind, he's the only, nobody else, he can make this up because nobody else was there. Then he goes on to say, that Casey had a black gun with an extended clip. Well, Mr. Collins goes, see how credible he is? He put it in his statement 10 days later. He was at the scene, ladies and gentlemen of the jury. He saw the gun there. He wrote this statement 2-3 weeks later. Of course he saw a gun with an extended clip. And by the way, when you get it back there, extended clip's only about that big. It's not talking about some clip like this. It's about that big. Then he states, after the other car clears the intersection, Casey then turns and past him. So he points the gun at him. So now he's got two threats. Remember now, this is weeks afterwards. This is weeks after the fact. He's making Casey out to be in some type of threat out there, threat to others. So what's he do now? Now he remembers when he's on the witness stand, oh, it was a mistake. Oh, that's right, because he can't stick to the same story because now he's got the video. Casey wasn't stopped. You know what? Mr. Collins made a big deal like going, I didn't know that there was a car that went through the intersection. Of course we did. But the problem is, it's not what he said in the statement. He takes the witness stand and says, oh, now wait a second. That was after the car had already gone through the intersection. You'll have the video and look at it. It was after it was through the intersection. Nobody stopped. It says they're going through, and I could still see everything. I could still see everything. I'll leave it up to you whether or not you believe that. So what else do we have? Chris Corne, okay. He didn't see a gun, and by the way, Rosser didn't see a gun when he made the turn. Chris Corne said he saw yelling, moving. We do know Casey had AirPods in his ears, so it sounds like to me that seems quite reasonable and believable. Saw Casey singing and dancing. But I find it kind of interesting that he spent, I don't know how long on Chris Corne. You can't believe him. But you should believe Jason Meade when he said, oh, I'm mistaken, that the car didn't stop. Oh, believe him. Believe him. But man, Chris Corne, can't believe him, even though we've got video. of Chris Corne in his van, pulling up to the intersection, stopping, in position to see. So Mr. Corne's mismemory should disqualify him in your minds, according to the defense, but believe him. Now, what's interesting about this whole scenario is there was no testimony that the defendant told anyone that he erred, that Casey pointed a gun. Instead, what he said was, and I think Mr. Collins admitted that, he said he waved a gun. Never mentioned. Oh, in his statement, pointing a gun. There were 4 people at that Carlton Estates intersection. Only one saw the gun. Yeah. So what's he decide to do? Well, this big violation that they're saying took place, this dangerous situation that they're trying to make out, he says he's going to go conduct a field interview. After he claims that he's witnessed this event, and he's going to do a field interview. So you have to ask yourself, did it really happen? I mean, yeah, he's going to, about pointing the gun at the intersection, did this really happen? Did he see somebody waving something, or did he see something, or did he see? We know Casey had the gun in the car. He had it on him. But has he embellished the story? I'd suggest to you that he has, after the fact, after he knew what he did at the home at 3996 Estate Street, State's Place. There's not a single witness to corroborate the defendant's assertion that Casey pointed a gun at him at the intersection, nor at the house. Neither place. It's just his word. So let's talk about at Sales and Estates. That's the intersection there. And you have to ask yourself, what was the defendant's attitude, demeanor, credibility? Was he acting as an objectively reasonable officer would at that time? Well, he did abandon his reasonableness, and he did resort to, as he characterizes it, hunting tactics to get his man at any cost. You heard what Professor Stout indicated, that he was outside the spectrum of generally accepted policing principles. The defendant never told Rosser or Yorkowitz about pointing a gun or even waving a gun at that time. Now, does that make any sense? That, and I think I asked him in cross-examination. Well, wait a second. You didn't tell him? Another excuse. I thought they knew. Oh, really? Did they say they knew, or did they say? Why would I tell them again, was his answer. Well, you'd tell them again so that you'd radioed for backup. You'd radioed for people to come and help you, and they're there, and you don't advise them what the next step is. You don't have a plan. You don't coordinate. Well, why would I do that? His answer was, because it would be redundant. And he stated, I assumed, I presumed. Wouldn't he want to know if they saw anything when the car went by there, when Casey drove by their truck? Wouldn't he even inquire about that? Hey, did you guys see anything? Tell me more. What do you guys know? What did you see? Did you see the same thing I saw? No inquiry. No inquiry. So ask yourself, what's going on here? What's going on in that man's mind at this point? Field interview, but he's on a pursuit. I don't know which one it was. He said field interview, which we discussed what a field interview is. You stop, and you know what? It could turn out what he said on the witness stand. It could turn out to be nothing. Well, wait a second. If it could turn out to be nothing, then did you see what you saw at the intersection? Because you're telling everybody this wasn't nothing. It was something. But he says, oh, well, I could have done that field interview. That's what my intentions were, and it could have turned out to be nothing. Doesn't make sense. Let's use some common sense in this courtroom. That's what I asked you to do. And you know what? The other thing he was is that, wow, after all, he says, and it's an unforgettable event of having a gun pointed at you. Well, you know what? It must not be that unforgettable. He forgot to tell Rosser and Yorkowitz. But that's what he said here. It's an unforgettable event. He claims urgency, man with a gun. Yet he would not coordinate for backup, which he claims. He just leaves them behind. Now, remember the 20/20 hindsight. Mr. Collins sits there and says, oh, that's all these guys talk about, it's 20/20. No, it's not 20/20 hindsight we're asking you to look at. You have to evaluate his actions to determine what he was thinking, doing, and his intentions, what he was going to do. Whether or not he was acting as an objectively reasonable officer. I mean, I'm going to tell you, I think even if you're looking at this and you hear what Professor Stoughton says, wait a second, this isn't how officers operate. These can create dangerous situations. He abandoned it all. What's he thinking? Why would he abandon it? After all, remember the one time when I said to him, why wouldn't you let him go into the house? I'm a police officer. That's what he said. Well, he abandoned it for a field interview. No lights, and and what kind of exchange was that? Mr. Meade, you could have turned your lights on. Oh, lights? Well, you wanted to identify yourself to Casey at the end of the street. Well, I had my vest on. Well, you're about, first he said 2 houses away, and then I think the next day I showed him a map. He's 6 houses away, okay? I guess he didn't remember how far away he was, or he's trying to convince you guys that he was much, much closer than what he really was. I had my vest on. What? You have lights? Turn the lights on. I couldn't take time to do that. Really? Well, how about your siren? Well, I couldn't do that. I couldn't do that. What's he thinking? This is an objective, reasonable officer here? To do a field interview? How about a PA? I don't think I have a PA system. I might. Okay, well, let's see here. So, all right, you don't have time to flick on your lights to show that you're an officer. At the end of the, so Casey, if he gets out, he can see you. Okay, well, you don't have time. What, did you ask Rosser and Yorkowitz? I mean, they're your backup. They're there. No, I didn't ask them. Did you tell your Rosser and Yorkowitz anything that you'd seen at the intercept? I thought they already knew. It's redundant. Redundant. It's not redundant, and it's not proper policing practices, regardless of what Davis wants to tell you. Davis has never testified but for a police officer. Davis is a police officer. That's his entire thing that he does. To come in here and to testify for officers. Ask yourself, you want to believe that? That, well, Mr. Davis, can you flip on his lights? Can you do this? Oh, his tactics were good. I think all of us using common sense can say, it wasn't. It wasn't. So who do you believe? Professor Stoughton or Davis? You know, the other thing about Davis is, Davis, he's the expert. All Davis did was take his written statement and adopt it as being true. That's all he did. Did he question anything else that was in controversy to his statement? Was his purpose to come in here to tell you that he believes him? Yeah, that's what they did. That's what they did. They brought him in here so they could put him on that stand just to tell you guys, I believe him. That's the only purpose behind it. Oh, so Mr. Davis. So, other officers were there, no communication. Other officers were not prepared to assist. Oh my word. You heard Rosser. My gosh, he took off. He admits, he opens up, looks down at the end of the street, and he says, hey, there's the guy with the gun. That's his statement. Rosser, Yorkowitz have no idea what's going on. Absolutely not. They didn't even have their thigh rig. They didn't even have their guns. They didn't have anything. So now, if this threat was as dangerous, now all of a sudden he says, now it's turned into a threat. Well, you heard Professor Stout. There's a difference between risk and threats and when you can use deadly force and not use deadly force. Now all of a sudden he's escalated into, well, now it might be an investigation, maybe not a field interview, maybe an investigation, maybe an arrest. I don't know. But man, he screamed down that road as fast as he could to get to the end. Rosser, Yorkowitz have no idea what's going on. They were not prepared. There was no communication. Over what? Well, I said to him, why? I got to stop him. What he's going to do? Well, what's he going to do? Got out of his car. Did Casey look at you? Well, I didn't see his face, but yeah, he looked my direction when I yelled. Okay. Did he point a gun at you? No. Well, you can't say yes because there's two witnesses there. I put money on it, though. If they weren't there, he probably told you he pointed a gun at him at that time, too. It's only when nobody can dispute what he says is when he comes up with that type of stuff. Stopped at the intersection. He didn't know we had the video. And then he comes in here and tries to tell you guys, oh, I'm going to change this. That's right, he didn't stop. He was driving through the intersection. And, oh, the other driver, I couldn't tell if he saw it or not, but, oh, so you were looking northbound? You'd be looking at the back of that northbound car. In a statement, he's sitting there where he can see the car coming. He's not being truthful. And if you can't be truthful about that, you got to start questioning yourself. What can I believe from this man? If you believe him on that, well, there's more. Then maybe you will want to question whether you end up believing him. So what happens at the intersection then? Professor Stout says an objective, reasonable officer would communicate, gather information, take precautions to protect themselves and others. Well, he must not have thought Casey was that big a threat because he left his backup behind without telling him about this extreme threat. If there truly was a threat, do you think he would really leave his backup behind that would be put in danger? It's because he knows. He might have seen something. He's after Casey. Okay, maybe when Casey got out, I don't know. Okay, we know Casey carried his gun in the front of his pants. We know from Sharon, which they say, by the way, and we'll bring this up a little further down the road, he says she's very credible. We believe everything that Sharon told you. Okay? Just keep that in mind. Casey's got the gun in the front of his pants. We know he carries it like that. Sometimes when he gets in the car, he takes it out. He lays it out. We know that. We're the ones that brought that out to you. They didn't. Gets out of the car. He's got his subs. Maybe he gets out and maybe something was seen put in his. I don't know. I only believe him. because Rosser didn't see anything. Too far away. Rosser didn't see anything that was threatening. So Professor Stoughton says at that intersection there, he was outside the spectrum of generally acceptable principles of policing practice. Now, they keep trying to say that Professor Stoughton was coming in here to testify as deadly force. He came in here to testify as generally accepted policing practices, and you heard his testimony. You heard his credentials. He's renowned in this area. That this is the generally accepted policing practices that are followed by most agencies in this country, including his. So, what's he say? Well, Mr. Collins makes a big deal out of it because he goes, he was truthful. He was truthful. Schroyer made a big deal out of it because he said he was running. Oh, really? Yeah, I did make a big deal about that. Because that's not what he said in that statement that he did after, I don't know, some type statement that he sat down. I don't know who helped him prepare it or whatever. But he said running. That's not what he said in the statement. He said quickly. There's a difference. And remember how he explained that? Well, and he kept saying running. Even after I called him on it and said, well, wait a second. You said quickly. Okay. And by the way, it's different than what Rosser saw. Rosser said he started seeing walking. So he says running. Why does he want you to believe he's running? Oh, he's eluding me. He's fleeing from me. He's taking off. But you know what was kind of interesting is the same guy that's fleeing from you and taking you off used his turn signal to turn onto a state's place. So I'm pointing the gun at the officer at the intersection. I drive on down the road, okay, and I turn my turn signal on. You'll see it. I want you guys all to look for it. Turns his turn signal on and say, come after me. I'm going to make a right-hand turn here. Come after me. I'm this guy that just pointed the gun. I'm going to tell you where I'm going. I'm using my turn signal. They didn't point that out to you. And by the way, I don't want to step into their territory of burden of proof, okay? I mean, I'm bringing this stuff up, but we don't have the burden of proof. They do. They do, and he knows it. And he stood up here trying to make you guys think we have that burden. They've got the burden. Trying to say that there's all this other stuff going on behind this case, that they didn't call witnesses, they didn't do this, they didn't do that. Well, you know what? They didn't call, well, they did call. I thought there was another expert going to testify. That's what it was told to you. Some guy named Jim Scanlon. I don't know what happened to him. I don't know why they didn't call him. But it's in their case if they want to try to show you their burden of proof. We don't call him. We proved our case. We sit down. Oh, Rosser, they didn't call Rosser. We didn't need to call Rosser. We proved our case. We sat down. And you know, I'm glad they did call Rosser. And the reason being is that when we get on down the street, it's kind of important as to Rosser's testimony. But let me get back to the running. Multiple times he uses the word running. We had that little exchange saying quickly, well, you know, sometimes I use words, quickly could mean running or, you know, whatever, and he continues to use the word running. may have sped up when he's going around the corner of the house. And if you remember, the testimony was, it says, Mr. Merkel said, then he tried to say sprint, and Mr. Merkel goes, wait a second, sprint? Well, it was a half a step before he got around the corner. You know, it's kind of weird because the defendant had said he'd already gotten in his truck and sped off to go, and by the time before he left, he'd lost sight of Casey. Remember we got into this discussion about ducking behind something? I said, is that police lingo? Yeah, he ducked around the corner of the house. Well, geez, I don't know. I don't know who saw what, okay? But I do think he can take this. He wasn't running. Maybe he'd run, walk, whatever, carrying his bag of subs. It's in the wintertime, okay? It's 12 o'clock on a Friday afternoon, okay? Doing whatever you do on a Friday afternoon, coming home from a dentist, going to Subway, taking subs to his family. This is really dangerous. Really dangerous on his part. So let's get to when he gets at the end of the street. So he gets to the end of the street, and I said, well, you know, when you got out of your truck, okay, you could have sought cover. I think you all remember that. And he's like, cover? I don't have time for cover. Well, wait a second. There's a tree. I didn't see a tree. Mr. Collins gets up and says, there was nothing in between you and him. Well, there's a tree right there. You saw Mr. Merkel's exhibit. So there was a tree there. Now, did he seek it? No. Did he immediately pursue him? Yes. So what's he do? He closes the gap with his assault rifle. He clearly had a rifle that was a long range, maximum distance, not something you use close range. It's select mode, fully automatic. He closed the gap within 10 feet, increases his risk, and he escalates the threat. Not Davis, but Stoughton told you that. Terrible. Terrible. That's not the way a police officer acts. He was not acting as a police officer. He was acting for some other reason. Stoughton says, no time pressure, you know. Remember when I said to him, hey, you just could let him go in the house. No, I can't let him go in the house. I have to stop him from what he's going to do. Stoughton says, can't speculate. You can't assume. In fact, what he said was, I didn't even know it was his house. Now, if Casey was fleeing, why would he run into a gated area, run up to a house? Why didn't he take off? Why didn't he run around the neighborhood somewhere? You know, did you remember what he said? Sometimes people hide under cars, okay? I didn't see any hiding. He still had the bag of subs. He didn't even ditch the subs. I didn't know it was his house. I had no reason to believe it was his house. Why would the defendant do all this? Because he abandoned all of his training to go after Casey. What was his purpose? What had he conjured up in his mind? Was he angry, mad, or to get this man? We know his policing policies. His policing policies are, I strike first, and his policing policies are, I like to hunt people, I love it. What do we have going on here, ladies and gentlemen of the jury? A reasonable, objective officer? I would suggest that we don't. Something else was taking place, resulting in a horrible shooting of Casey. Because why? Casey doesn't comply. Why doesn't Casey comply? He's got earbuds in. Now, you can take this into consideration because it looks at what's Casey doing. Is Casey really not complying to what he's asking about? Or did Casey not hear him? Remember when I said, let him go, just let him go in the house. He retorted indignant, incredulous. I'm a police officer. I have to stop him. He could hurt people. I had no reason to believe he lived there. Those are his words. Now let's get to the shooting. It's unjustified shooting. Professor Stoughton, it's up to you to decide He's the only one that was there. Had he waited a little longer, maybe he'd had his back up there. He's the only one there. Shoots before anybody gets there. So what's he said? Professor Stoughton says it's up to you guys. Davis goes, I'm making the decision for you, okay? I'm going to take it out of your purview. I'm going to tell you, yeah, this was good. Why? Because I read his statement. We don't even know if Davis ever even interviewed him. We don't even know if Davis ever even met him. He reads a typed statement and takes it and runs with it and comes in this courtroom and tells you. What kind of expert is that? I submit to you it's not an expert. It's a hired gun. So, let's look at what the defense presented to you. Okay? Okay, let me move up. Defendant claims he identified himself. He yelled multiple commands. Okay? Defense tries to bolster this by calling Sheila Staniford. She says two different stories. One, she's driving by the house when she hears the defendant, And the other story to the police, days afterwards, she said, she arrived home from the funeral at 11:30. She looked out her window, had concerns about a truck, which was a heating and cooling truck, and then she heard the commands. Okay, well, the problem is that was Mr. Corne's truck, and we have GPS to show Mr. Corne was in the area. So you got the Stanford, they're presenting this lady that tells you two completely different stories? To do what? To support that Stanford heard, drop the gun. But you know what's funny about this? Rosser didn't hear that. A trained police officer for years who works with this man. You know what Rosser, if you recall, what Rosser said was, the only thing I heard was two things, two times. Show me your hands, show me your hands. But they bring this woman in here to say she trumps Rosser. Who do you believe? Show me your hands, show me your hands. And he said, that's all I ever heard. I didn't hear anything else from this man. Show me your hands. And then I heard the shots. Not drop the gun. Defendant approached, aimed his rifle, center mass, center of his back. He couldn't see Casey's hands. Casey's back was turned toward him. Casey was doing something at the door. Could he be unlocking it? I don't know. Claims he opens the side door, storm door on his back. Could he be going in his home? I don't believe it's his home. Steps into the threshold. Casey, then he says, turns and raises his arm upwards and points the gun at me. Not as he's raising. That's not what he even showed you on the stand. He does some little movement like this. I don't know. You're going to have that storm. I don't know how you turn. What is he slamming into the storm door? What they conveniently leave out is there's a storm door there with glass and metal. He's got him inside on the threshold of the house. I just thought about this the other night. It was like, well, if somebody calling over my left shoulder, I'd look this way. Because that's where Meade is. Meade's not over here. Why would he point the gun that way? Because they have to try to explain to you, mix things up, that how the shots got into the back. And by the way, the coroner said slight right to left. Cula's her diagram here, which was, I submit to you, wasn't shown. You'll have it. But look, this is the part that was cut off in that diagram they just showed you and closing. She has the shots coming out. Here's the gate. She's showing the directionality. Not that he's standing in here. Why would they show you this and try to perceive something that's not? Guess they didn't think I'd get up and show it to you. But Cula's testimony matches the coroner's. Outside to inside. Back, trajectionality. Slightly right to left. Upward. And it makes sense. He's at a lower elevation. You were out there. To get in the house, you have to take the step up. You're on a porch. He's at a lower elevation. Ms. Merkel showed you the trajectories. He's absolutely right. Look at the one center mass. Where did he hit him? Military. He's fired these rifles. He points. He aims. He's got a red dot. He hits center mass because guess what? I'm trained to aim center mass. Not trained to enter his butt. Not trained to enter his side. I didn't miss him. tried to tell you something on witness. I tried to keep track of him as best as I could. He's a marksman. Then he says, Casey immediately drops, but yet the gun's not out. Oh. Bam, immediately drop. How'd this gun get underneath him? Well, he has to say it's underneath him because guess what? Rosser was there. Rosser saw the gun here under his chest. The holster's in the front of his pants. Meade can't change this story. There's a witness. The only ones he can change is when there's no witness. It's under his pants, or he changes if there's a video. It's under his chest. So he has to, and then guess what he does? I rolled him over and it's under his right arm. Right arm? And then you see what Mr. Collins did? Well, wait, right arm, torso, kind of the same, whatever. Because he never said anything in his statement, right arm. Comes in here and tells you, right arm. Why? Because it wasn't. He didn't put in his statement, a law enforcement officer, right arm, that's important, Mr. Meade. Not the right arm? I said, I couldn't see his hands. Oh, wait, I was yelling, show me your hands. That's not what Rosser said. Heard, show me your hands in shots. No other show me your hands. I'm asking you, what do you think's going on here?
Counsel want to approach?
I'm almost,
115.
Okay. Rolled him over by his shoulder. Rosser says by his feet. Where were Casey's hands? By the way, Sharon's really believable. They believe her 100%. Sharon said his hands were out when she saw him laying on his stomach. Janae said his hands were out when he was laying on the stomach. I guess they're right. I believe Sharon.
Objection.
Overruled. Closing argument.
Okay. Actions by the defendant. When he rolled him over, I believe the AirPods clearly would be visible, yet he doesn't know whether he's dead or alive. No life-saving procedure. He panics. He begins to cover up. He runs out to turn on the lights to the truck to make it look like Casey could see him. He held up the ambulance. Don't come yet. Don't come yet. Truck giving the impression the lights were on. They submitted a photo to you guys saying, look, here's some lights. Here's some lights. Well, it turns out, why did they submit that photo to you? And in their opening statement, they said they were going to present evidence to you. He was calling down the street with his lights. They never did that. What changed? Maybe they saw Rippy's body cam? I don't know. Defense counsel says lights were on. So what was the defendant thinking when he shot Casey 6 times? Well, this exchange took place on direct examination, and it certainly tells you his unreasonable, speculative, unhinged thinking. Mr. Collins, what type of harm can someone running through a neighborhood cause, Jason, based on your training and experience? Defendant. So the urgency of it again, being that I'm on a tactical team, we do barricade, hostage situations, things like that. If he gets into the home and takes hostages, he could go into the home, barricade himself. He could set up an ambush, police officers who've experienced all this. And then Collins goes, ask another question. He goes, and he says he was a high threat. Then I asked him, why didn't you let him go in? His answer was, I had to get him to stop from doing what he's doing. Well, here's what he said on the porch. When we're playing this, he didn't know he's being recorded, and he's trying to say now, his excuse is, I was saying why there was a call. You tell me if you think there's a call. He admits his reason for shooting Casey. You listen. He came out on the street, gun in his hand, going to the side door, gun in his hand. Again, no threat, mention, no fear, only going in the house with a gun. Throughout this entire trial, his unreasonable pursuit and hunt, Casey never said a word to the defendant. Not one word. That's what was missing in this case. What did Casey say? It's pretty sad. Casey didn't speak one word because he never yelled anything. He never said anything. Why? Because he never heard him. He never heard him. Casey never said a word.
Your Honor, would object and ask to approach.
Yeah, can we approach? You get all that?
I'm sorry, talking so fast, I'm under a time limit. So here's what I've asked you when you go back there. Ask yourself, what was Casey's big plan? He's going to shoot an officer.
Sustained, sustained, move to strike.
Thank you, Your Honor.
Okay, Casey did not point,
Stopped, Your Honor.
Casey did not point his gun at the
Objection, Your
defendant.
Honor.
Sustained, move to strike.
The defendant has not met their burden of proof. This is not justification, ladies and gentlemen of the jury. This is murder. Thank you.
All right, ladies and gentlemen, your initial conduct, you can go back to your instructions on the top of page 14. Your initial conduct upon entering the jury room is important. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after discussions and considerations of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Before you can find the defendant guilty, you must unanimously agree on your verdict. On behalf of the public and parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned, you may discuss the case with anyone, but you are not required to do so. Whether you discuss the case with counsel or anyone else after you are discharged is a matter of your own free choice. When you retire to the jury room, you should select a foreperson. The foreperson will be responsible for exhibits and the verdict forms and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. If you have questions, write them on a piece of paper and give the paper to the bailiff. If all the 12 of you agree on a verdict, all of you should sign the appropriate verdict form in ink. Advise the bailiff by turning on the green light, and you will then be returned to the courtroom. Alternate jurors were selected to serve in the event of any misfortune befalling a member of the panel. Each of you will remain as an alternate of this panel until your jury has reached a verdict. If your service is needed, you will be impaneled with the other regular jurors and deliberations will start anew. You may return to the, it says to the general jury room to wait further instructions from the court. Since you are still an alternate juror, you are not to discuss this case with anyone, and you are not to tell anyone how you would vote on this case. And ladies and gentlemen, we're going to get you all the exhibits. One of the things, as I mentioned to you, if you want us to bring in the firearm, we will bring in each of the firearms. Is it a deputy escorts it? So you can see and feel, but I'm not going to have a firearm and ammunition, live ammunition, back in the jury room. So if you need to see the ammunition, we'll bring that in and take the guns out and those kind of things. We'll get everything to you.
All rise.
It's a verdict form. If you guys need to stay, do you need to put anything on the record?
Yes, up at sidebar, Your Honor.
Okay.